What would a meeting be without me messing up the microphone? So he's going to record on Zoom, so we have a recording of it. It is going live to the net so people can see it, but we are having a little bit of issue with our YouTube stream. So did I say that right, Nathan? Okay.
Okay, well then I will call to order the Newburgh School District Board of Directors meeting for August 12th, 2025, and we will start with the flag salute with Director Hayden.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And just for the minutes to reflect that Director Wolfer is not in attendance tonight. And do we have any agenda additions and or deletions that anybody needs to request? Okay, hearing none, let's just move into the consent agenda. I would like to mention that under the new hires and resignations, that while it seems alarming that maybe Mary Jane Bachmeyer's name and Andrea Nichols' names are on the retirement, if you please make sure you know that they're staying, that they're coming back. So I don't want anybody to panic by seeing that in the minutes. And then, of course, it's really critical to outline or identify and celebrate the donations that we get. The Austin Family Foundation has made considerable donations to us for the Career Connect Learning Program to the tune of $615,000, the Student Health and Mental Wellness for a little over $394,000, and then Newburgh Dundee School Tiger Cubs at the tune of $294,602. And Crohn's Appliance, and who is very generous in the community, has also given a dishwasher to the Antonia Crater staff. So.
Yeah, I just wanted to echo that. I can't tell you how impressive the generosity of the Austin Foundation is here. The total amount of giving is $1.3 million to the district. The career-related learning pieces will are invested in people and time at Catalyst and at the high school. The student mental health and wellness is providing counseling, mental health services to our elementary schools. There's other programs that are also working the middle school. They've supported the pre-K, both classes of pre-K. Again, I just want to say how deeply we're appreciative of this kind of generosity. I don't know any town in the metro area that has, and again, we saw it last year when we did the RIF and how people stepped up from the community to help support the district. I just can't say enough about how special that is, and we're appreciative of that. So just want to make sure that I said that on the record.
Great, thank you. Do we have a motion for the approving of the consent agenda?
Real quick before we do, I just want to give a welcome to the folks that are joining us as we accept some probationary contracts. I want to thank the folks that have served in Newburgh and are off to their next adventure. I also wanted to kind of a shout out to my fellow directors here that we took our oath in our July meeting, but I think there is a stray comma in that oath of office, and so I just wanted to submit that for revision. So I think in the oath it should say, "I will support the Constitution of the United States, comma, the Constitution and laws of the state of Oregon, comma, and the policies of the Newburgh School District." So my recommendation is to remove the comma after the second Constitution.
Gotcha.
Oxford comma, right?
It is. Well,
you know those commas.
Commas.
So tricky.
Everybody loves commas. Everybody loves commas.
Okay, would anybody like to make a motion?
I
With the-
move that the Newburgh School District Board of Directors approve the consent agenda as presented,
As amended.
as amended.
Second.
Any further questions? Not, what am I doing? Oh, we'll do a full vote. Sorry. All in favor, say aye. Aye. Motion carries unanimously. It has been a while. Okay.
Can
Uh,
we, I wanted to just announce one other person.
Oh, yes.
We've got our new executive assistant to the superintendent and to the school board is in our audience today. It's Jackie Torres. And she is here ready to start learning, taking minutes and doing all of that work. She's been at work a full 7 days. So, but it's been a pleasure. She brings with her a wealth of experience in both the building as a attendant secretary at the elementary level, as a bookkeeper at the high school level, and she has a BS in accounting. So she was made the senior accountant at Tiger Tualatin. And then we've hired her way to kind of bring all of that set of skills to our district. And a native Spanish speaker just has been a really great addition. With Tabitha leaving, those are big shoes to fill, but she's doing just a great job. So again, just want to introduce Jackie Torres.
Welcome, Jackie.
Thank you.
So this is a time for a public forum. If there's anybody in the audience who has a comment to make. Okay, hearing none. We're going to move into, we have a mandated training regarding civil rights, and I'm just going to make a general statement to sort of bring us into context as to how we got here today. And this happened in the 2021-2022 school year, and none of the current board of directors were directors at the time. But this is a result of a complaint that had been made to the Department of Education regarding a potential civil rights violation. And the board member at the time, who was on the board, filed the complaint. And then in September of 2022, the Department of Education accepted an appeal from that individual. So then that started the review process for the Department of Education. And just in case anybody out there wants to know, that was case reference 2022-MM-17. The Newburgh School District received a statement from the Department of Education, and this is what it said. It said in 2021-2022, and I'm just taking a section out of that document, which is in our records. The board did not reasonably accommodate a board member's disability, denying that person the right to fully participate in those meetings on the same basis as her peers. And this had the complaint alleged 3 different board meetings in which this happened. And so in September of 2024, our board at the time entered into a conciliation agreement with the person who was identified in that complaint. And there were a number of things that we agreed to as a board that we would do. And one of them was to have this training. And I think in fairness, the Department of Education kind of wanted us to move a little sooner than having it today. But Rebecca Pyros, who is the named person in that complaint, really asked that we do it when we have a new board seated. And I really appreciate working with Rebecca on that for the conciliation agreement. And the Department of Education had accepted all of the changes that we had made up to that date and recognized that we would comply fully with the complaint, with the agreement through this training. And so that is why we are here today. And I want to introduce Miranda, who is going to be doing our training. And when this is completed, then do we send something to the Department of Education, or do you check in with somebody, or there's a next step to sort of show that we've been in compliance? Yes. And so we're going to do the training. I know that we'll all listen and pay great attention. Director Wolfer's not in attendance, but he has committed to listening to the training. He had a work conflict. And then at the conclusion, I have chatted with Rebecca, and she's going to come up and give a little statement to the board. So we'll go from here. It's up to you now. Thank you.
Wonderful. Thank you. So I want to confirm I have about an hour and a half. Does that sound right to you? Okay, great. Perfect. And let me make sure this works. Okay, I'm also not used to sitting down and providing training, so I might move around a little bit. This is rough on me. Okay. Okay. So, first and foremost, I come from the Oregon Department of Education. I'm a civil rights specialist. And in my role as a civil rights specialist, I work with the protected classes under the federal laws of Section 504 and Title II of the ADA. Oregon has its own non-discrimination statutes, so I also work within the protected class of disability under Oregon law. And then I'm going to talk briefly in a little while about Oregon's requirement to have civil rights coordinators, but it's our unit that oversees the civil rights coordinator program for the state as well. I have colleagues in my unit who oversee the protected classes under Title VI and Title IX, and we collaborate very closely. With that said, this is a training, not legal advice. I am here to provide technical assistance. I hope that you all have access to this as a PDF slide deck because I have hyperlinks throughout. One thing I want to note that anything that's external to the ODE website is subject to change. So we have noticed that the U.S. Department of Education's web pages and links aren't always working right now. So I tried to find original sources like within the CFRs instead of the federal agencies' web pages, but just note that as well. Today is also August 12th. Tomorrow is August 13th. Things change. So as you go through those as references and resources, please make sure that nothing has changed in state or federal law and consult with your legal counsel as needed. So ODE serves the entire state. That's over 90,000 educators. I was just talking to a district who has 4 students. We have a very diverse state as far as how big these districts are. And no matter what, we still have to follow the law, right? So Newburgh is its own entity. You are unique in your space, and our state and federal requirements are the same, whether we're at Salem-Keizer, Newburgh, or in Vail or whatever. Our civil rights unit is growing. So probably when you first went into conciliation, it was a really small care team. And then we've expanded our civil rights unit to now have other specialists such as myself, as well as support specialists. So now families and community members can reach out to the department and get support on navigating their children's educational civil rights. So just know that support is available to them, and it is not quite an advocate, but someone that helps them navigate really difficult systems, right? Our educational systems are hard to navigate. So today we're going to go over the ADA's general provisions, and then we're going to go through the Amendments Act as it was amended in 2008. We're going to go through some specific provisions that, just for your awareness, we can't get through all parts of the ADA, right? Then we're going to talk about Oregon-related laws, so how those intersect here in Oregon, including non-discrimination and civil rights coordinators, and then we'll go into a quick review of how that complaint process works. And my style is, if you have questions, ask them. I can keep up with that cadence just fine, so it's better for me to answer questions as they come up within the context. So that's basically what that says. Okay, so just to level the playing field, some terms and acronyms that we see throughout this slide deck in training. OCR is the U.S. Department of Education Office for Civil Rights. They have the legal authority to oversee federal civil rights laws as they apply to our public schools and public charter schools. So you can have complaints filed directly with OCR, versus what kind of maybe happened in other situations where there's an appeal to the state. OCR also issues guidance, dear colleague letters, and the such to help us interpret the regulations as it applies to our public school systems. The DOJ is the Department of Justice, so actually the ADA falls within the scope of the DOJ. We are seeing, however, right now, multiple agencies get involved in investigations. So the Department of Energy could investigate a school district if they receive monies from those systems as well as agencies. So just be aware, I'm referencing the OCR and DOJ, but there is possibility that other agencies, depending on funding sources, could be involved in a civil rights investigation. The ADA is the Americans with Disabilities Act, and you might see ADA-AA, that's the ADA Amendments Act, so it gets just longer. Section 504 is shorthand for Section 504 of the Rehabilitation Act of 1973, and CRC is what we're calling Civil Rights Coordinators here in Oregon. So to understand federal civil rights laws, we have to think of it like from the law all the way through to guidance and dear colleague letters, right? So you have the actual law. So like the ADA, you can read the law itself. It's a non-discrimination statute. And then it has implementing regulations. So you go even deeper. And so different agencies will have implementing regulations that they must follow. So we look at those regulations and try to interpret what does that look like for our public school systems under Title II, right? And then we have federal agencies that release more guidance when it becomes confusing, right? So OCR might release some guidance on how to interpret Title II of the ADA as it relates to Section 504 because they're sister statutes. And so that's a way for us to look at deeper interpretation of these laws. And then we look at case resolution. So when there is a filing of a complaint at the federal level, we can look at those case resolutions and say, okay, this is how the OCR or DOJ would find maybe in a similar situation findings for a similar complaint, right? And if you're ever interested, like you can see how those ebb and flow over time and where those complaints are lying right now through the OCR website. And then we have court decisions, right? So not only under the ADA do we have this way, the compliance mechanisms of agency oversight, but we also have the ability for folks to file civil lawsuits. And so we're able to read into those court cases to understand how the law is applied in those situations. This is just a disability civil rights timeline to give you some context on where these laws live. So 1954, Brown versus the Board of Education, that was the first time that we were actually allowed to educate students with pervasive disabilities. Up until that point, like it was almost a prohibition to include students, right? So we desegregated schools. That also meant that we started to integrate students with disabilities. But it wasn't until 1973 that there was actually a civil rights statute that says we cannot discriminate on the basis of disability. Section 504 applies to federal recipients of federal funds. So Section 504 applies to y'all. It applies to the state. It applies to anyone receiving federal funds. And it has implementing regulations specifically for primary and secondary schools. So when we're talking about ADA and Section 504, we're all kind of talking about them in conjunction because they're doing the same thing as a non-discrimination statute that applies to recipients. Then we have them basically what became the IDEA. So we have special education, right? So, and we're not going to talk about that today because that's really regarding students, but that's an intersecting law as well. So just so you know, students who have services under the IDEA and special education also have civil rights protections under Section 504 and Title II of the ADA. So they could go through procedural processes to get their IDEA requirements fulfilled, like making sure that they're getting a FAPE, all of those things, but they can also file civil lawsuit for discrimination under Title II and Section 504. So the non-discrimination statutes live within those two laws. The access is through IDEA and special education. Then in 1990, the ADA passed, and the ADA extended basically what Section 504 did to all areas of civil life. So you might notice that you go to a concert and there's going to be accessible ramps for folks to be able to also attend the concert. Or even if you go to a hotel, there should be rooms that folks with disabilities can access. So it no longer was just recipients of federal funds, but it became all parts of civil life have an obligation. And we'll talk about, there's 5 titles to the ADA, one of those that we're talking most about today, which is Title II. And then in 2008, they went through an Amendments Act, and so that became effective in 2009, and we'll talk about what that meant for us. And it actually meant a lot because I started working in public ed before 2009, and our definition and scope of who we consider to have a disability was much more narrow. And at the Amendments Act, we broadened that scope of individuals who are protected under these civil rights laws, and it took us a while to catch up. Right. So we're still seeing schools who make mistakes in these spaces because they need abundant proof of disability, and Congress says no, you don't need abundant proof of disability. Shouldn't be exhaustive. We can support people and provide protections without a lot of evidence. So we're going to dive really quickly into the basics of the ADA. So again, there are 5 titles. Title II applies to state and local government, and that's you. So Title II is that sister statute to Section 504. And it's important to understand that this applies to public schools, public charter schools, ESDs, any part of state or local government. Title I also applies to y'all as well because of employment practices. So we're not going to talk about that today, but there are employment related obligations that the district has, and your HR department is probably well aware of that and works with the employees at the district to assure compliance with Title I. So this is where you'll see I have some links. Anytime you see those blue hyperlinks, if you want to see where this comes from, I don't make it up. So that's where it comes from. So first, really, this is the non-discrimination statute that says no qualified individual with a disability shall, on the basis of their disability, be excluded from the participation of, deny the benefits or services, programs, or activities of a public entity, or be subjected to discrimination by any public entity. Okay, so we're not excluding, we're not denying benefits. Any program or activity that you all sponsor or partner with is under your jurisdiction, right? So you're also thinking about not only Newburgh Dundee Public Schools, but those partner after school programs that you're engaging with, right? Because that's part of your programs and activities. So this applies to our public schools, ESDs, state and local government. And remember, Section 504 is that sister statute. So we weren't allowed to discriminate since the 70s. Then in the 90s, ADA told us that again. And then later again in 2008, we re-upped some of those obligations. So this is where the challenge is really understanding disability. There are 3 prongs of disability eligibility. One is an individual determined to have a physical or mental impairment that substantially limits one or more major life activities or bodily functions. That one's pretty easy, right? But we have 2 other prongs. One is someone who has a record of an impairment, or someone regarded as having an impairment. That means people who have a record of a disability have the same civil rights protections as someone who has a disability. Same thing if we treat someone as if they have a disability, they have the same civil rights protections as if they actually had a disability. So for example, a record of an impairment, my school-based example is always like, this kiddo had leukemia when they were in kindergarten. It's in full remission. They tell the high school football coach they're going to try out, and the football coach says, you need special clearance because of the leukemia that you had. We don't want you to get injured. That treatment might have made your bones brittle, so you need special clearance. That's a record of an impairment, and that's discrimination under the law. You can't treat that child differently simply because they once had leukemia. Now, do we all go and get physicals? Yes, that child will get the same physical that any other student would. Regarded as prong, some examples are a person has a really significant scar, but it doesn't actually limit them in any way. But if we treat them differently because we think it does limit them, they're protected under the law. Another example that was really big for a while was folks who had family members who are HIV or AIDS positive, and you treat that child or their family member as if they're HIV positive. It doesn't matter that they're not. If you treat them that way, they now have the civil rights protections afforded to them. Okay. Are there questions about that piece?
I guess my question would be, how is it determined, or how would we know if like that third prong, if it's not us making that,
Yeah, it's how you all regard that person. So it's not somebody regarding themselves necessarily, but if the system is treating them as disabled, then that protection is there for them.
okay.
Yeah. I always warn teachers, like, don't talk about that kid as if they have ADHD and they don't have ADHD because now he basically has ADHD, right? Like, don't talk about him that way. Like, yeah, he's just be careful about how you talk about people and what we think we know about folks, right? So we're going to go deeper into defining disability because the Amendments Act helped clarify some of these pieces. So we'll get to that momentarily. The other thing that the ADA did is it required every large enough entity to designate a responsible person to oversee compliance with the law. And so generally we call that person an ADA coordinator. And that person has the obligation to oversee compliance with the ADA, publish grievance procedures, receive complaints, and resolve complaints regarding discrimination on the basis of disability. Now, this person probably wears multiple hats, so it doesn't have to be a person that their only job is ADA coordinator, and it could be multiple different people. So you might have someone who oversees web accessibility, right, for all your virtual platforms that has an ADA coordinator role, as well as someone maybe in HR that has an ADA coordinator role. As long as everyone knows who's doing what and there's collaboration there and you have a grievance procedure and somebody's overseeing compliance, you can kind of divvy out those responsibilities. Sometimes this person wears other hats like the Section 504 coordinator. That's fine as long as they're still defined as the ADA coordinator too, because the ADA does have provisions that are not within Section 504. So we're going to go into some of those special provisions under the ADA, but you would want to make sure that everyone knows when they get onto your website or they get to your handbook who that ADA coordinator is and how to reach them and how to file grievance. So that's part of this notice. So every public entity must provide notice to any applicants, participants, or beneficiaries, any interested person on the regarding the ADA and the protections against discrimination. Luckily, you probably have a non-discrimination notice already. A notice of non-discrimination is required under Oregon law, and so as long as it fulfills that requirement as well within the ADA, it's probably compliant. And in our Oregon law, the notice of non-discrimination must be continuously available on your website, posted in multiple locations, available in languages of the community served by your district, and disseminated annually. And so this statement contains that non-discrimination requirement, and you're identifying disability in there as one of the protected classes, both because of Oregon law and because of these federal laws, and the contact information of the ADA coordinator, and then we'll talk about the civil rights coordinator as well as all the other federally required coordinators. And then for this to be compliant on your website, there has to be a direct link to your discrimination complaint process and procedures. Questions before we move on?
The protected classes are different in the state of Oregon versus federal.
Yeah, so there is overlap between federal and state, thank you, protected classes, but Oregon has its own defined 10 classes. So you won't see some of these in federal law. Right now, Title IX is not recognizing sexual orientation and gender identity, but Oregon law does. So that is still those are protected classes here in Oregon.
Generally as an organization.
Nate, can you turn
Oh,
your?
sorry.
I was an audience member. And generally, as an organization, we're directed to go with the most restrictive.
So you need to have those 10 to be compliant with Oregon law. You can have more, but then your question would be, how are you compliant? Would you go through the same complaint processes if you define more protected classes? Oftentimes I'll get the question of like, what about socioeconomic status? Well, in Oregon, that's not in law. If you want to have your own policies, you need to establish those and then create those systems around that. But those 10 have to be represented.
Dr. Peters,
Yeah.
before we go on, I just want to ask who does serve as our ADA coordinator in our Section 504
So Dana serves as both ADA coordinator and then our 504 coordinator. We also went through an OCR audit. So we were just last year, all of this was gone through website where all of the pieces are. So we've just been through that process to agree to make sure that we're compliant.
Thank you.
Okay, so the ADA went through the Amendments Act in 2008. So as of 2009, we have some different understanding or a broader understanding of disability. So this offered broader coverage. This is a kind of the primary purpose of the ADA Amendments Act was to make it easier for folks with disabilities to obtain protection under the ADA. So what Congress said is that the term disability or the definition of disability should be construed broadly in favor of expansive coverage. Whether the question of whether an individual meets the definition of disability should not demand extensive analysis. So a couple of highlights to this here is substantially limits. Remember, a physical or mental impairment that substantially limits one or more major life activities is not meant to be a demanding standard. So it's not whether or not someone can do something. Is it more difficult? Does it take more time, right? Condition and manner, duration. An impairment that's episodic or in remission is a disability if it would substantially limit a major life activity when active. The easiest example of this is epilepsy. So when you're looking at an individual who has a seizure disorder like epilepsy, you would be asking the question, does that individual have a physical or mental impairment that substantially limits one or more major life activities when they're having a seizure? If the answer is yes, they are defined as having a disability under the ADA in Section 504. That's also true. Well, I'll talk about that in a second. The determination of whether an impairment substantially limits a major life activity is made without regard to the ameliorative effects of mitigating measures except for just regular eyeglasses. So when we're asking, do they have a physical or mental impairment that substantially limits, we're asking that when they're not medicated or when they're not using the FM system or when they're not using those tools and devices. Okay, so yes, they might be using these things that help them and they aren't perceived as disabled when those are in use, but that's not the question. The question is when they're not in use, are they considered disabled and do they have those protections? And
I'm sorry, I have one. What's
Yep.
what's FM systems?
Oh, an FM system would be like in a classroom, maybe a student who's hard of hearing
Okay, thank you.
would get to have kind of a projected system for them. And then we just can't have a standard in which we say, transient or not, impairments lasting for a certain amount of time don't qualify. What OCR and DOJ would say, that's case by case. Like if that impairment is going to last 5 months and it's so significant that it does limit their major life activity, it can still be considered a disability. Another example is traumatic brain injury and concussion. So we might have someone who has a mild TBI, or we think it's a mild TBI. We would think that they're going to start to improve over time and they're just not following that trajectory. We don't need to wait and say, well, once it's, they've been impaired for 6 months, so we're going to make sure that we're, protecting them. We would assume that most likely this is substantially enough, right? So when it comes, it's funny because we're thinking about these in adult spaces, in child spaces. This is really hard for educators. Like the kids using medication for their ADHD. What are you telling me that they're disabled and need 504 protections? But that's the law. And even if 1 in 9 students have ADHD in 2025, which is what the data suggests, that means one in 9 kids have Section 504 and ADA protections, right? Now, not all of them necessarily need 504 plans, but they might need some type of service. We'd have to determine that. So this is that question of what is substantial? And substantially limited in a major life activity, we're comparing that person to the general population and the condition, manner, or duration in which it takes that person to perform that major life activity. So again, it's not whether they can do it, but the conditions, manner, or duration. So we're thinking difficulty, effort, time, pain, side effects of medication, or any other type of burdens associated with treatment. So we're just kind of thinking the challenge again is there is no bell curve that we're using. There isn't like a standardization of like when does someone suddenly become disabled. That's always case by case, and determining kind of in the general population as compared to other folks. So for the ADA itself, there's some really important specific provisions to be aware of. One is your program accessibility. And so your programs need to be accessible for individuals with disabilities, including your physical spaces. And that means anytime that you build a new building or renovate or update any type of building, they have to be compliant with the ADA regulations. I'm not going through all those because well, first of all, I don't think I know them all. There's so many. And it would be days of training, right? But that's why you have the folks that you have to consult on those projects, because you would want to make sure that that addition or that renovation to a really cool old building it becomes accessible to folks with disabilities. And there's all types of accessibility features that we need to be considering. The ADA even has accessibility requirements for playgrounds and how to make them accessible. So it's just making sure that your ADA coordinator, facilities manager, all of those things are working together to get the right consultation and contracts. So all new buildings or alterations have to meet the 2010 ADA accessibility design. The other one is communications. So basically your program needs to provide communication to individuals with disabilities so that they can receive the same benefit as anyone else with don't need communication accommodations. And the thing to think about here is in determining this, it's usually up to that individual. Okay, so they know what their communication needs are, and if they need ASL, they need ASL. Like working with that individual on knowing what their communication preferences are is really important. And so if you have someone who's going to come to a board meeting and needs communication services, you have a statement on your webpage that says, let us know within 48 hours or whatever, and we will get that service for you. And so it's just very important to note that we're working with that individual to determine what their communication needs are, because it's hard to say that all individuals who are hard of hearing need the exact same thing, right? Or all individuals who have low vision need the exact same thing. Okay, this is the ones that people get in trouble with a lot. And so I'm going to spend a little bit of time here. And there's been recent cases, very recent cases still. And I'm like, this is like the easiest answer in the whole wide world because it's like so cut and dry. There's so little that's cut and dry, and this is really cut and dry. Okay, service animals. This is a specific provision under the ADA, so you won't find it under Section 504. You're not going to find it in the IDEA special education. This is an ADA requirement. And you must modify your policies, practices, and procedures to permit the use of a service animal by an individual with a disability. By definition, a service animal is a dog or a miniature horse. That's it. There's no other animal that's a service animal, okay? It can be any kind of dog. The breed does not matter. Okay. And you can only ask that individual 2 questions regarding their service animal. One is this animal required because of a disability? And 2 is, what task has it been trained to perform? You do not ask about what type of training it received. You do not ask for them to show certification of that training. You don't ask them about the nature of their disability. You don't call Dave Parker and say, can we allow this person on campus with their service dog, because it's not up to him, right? It is an ADA requirement. So those are the 2 questions that can be asked. The problem often comes is that we don't tell the front office staff that's what you can ask, or the teacher. I think the most recent case that I was looking at was a parent was disallowed from going to their child's field trip as a chaperone because they came with their service dog. And so the parent left and the kid's crying, and it's all because the teacher just didn't know, right? We don't train our folks, frontline staff, on what the requirements are. Now,
Question.
yeah.
On the, I mean, it seems like it's pretty obvious the answer to the first one. If they say no, then it wouldn't be a service animal. With the second one, what would the goal or, what were you looking for?
So what you're looking, basically think about it as the service animal is an extension of that person. So is that animal doing something that they couldn't otherwise really do, but they would need as part of their disability, right? So good example, I mean, some are really obvious, right? So someone who has low vision might have a seeing eye dog, but there are also there are dogs that are trained to detect a diabetic event, that are trained to predict seizures and be present with a person who's having a seizure. With PTSD, that's also one where it's like predicting like traumatic response. A comfort animal is not the same, right? So it has to be a function or a task that they've been trained to do as an extension of that person. Now, they don't have to go through any formal training. That person can train their own animal. They could have their best friend train their animal. The ADA does not require specific training for service dogs or service animals.
So I guess the reason I ask is like a front desk individual asked that question.
Please err on the side of sure. And let the animal
Yeah.
come in, and then if that person can work with whomever, their leadership, to say, this is what the answer was, what I'm not sure if that's right, that's fine. But really, is it something that the person wouldn't be able to do or need help with otherwise? Yeah. Just think of them as like an extension of themselves, right? Yeah. There are times that a service animal, so obviously you're more likely to see service dogs. We don't have a lot of miniature horses. They are allowed, but it's rare that we see those. But there's only two times that you really can take to request that the animal be removed. And one is if they're out of the control of the handler and the handler cannot regain control. And two is if they're not housebroken. So if that dog is going piddle all over the school, no, they cannot be there. So those are the only two times. So we're gonna do an activity. Oh, I thought they were gonna come through it separate. Okay, so we're not gonna look at each one. Let's look at the first one. So a community member with a panic disorder shows up to the school board meeting with a service dog. Before entering the front doors, a staff member stops the individual and tells them that dogs are not allowed. Until the superintendent makes that determination for it to be on campus, the dog cannot enter. So what's the problem?
We don't have a dog here as like, to practice with, which is really sad to me because I love dogs. But
Should have brought
the problem is that the staff member is not educated about the rules.
Yeah. And there's no one individual that's like qualified or certified to allow or not allow a service animal, right? There's not one person that makes that determination. Okay, a community member with a panic disorder shows up to a school board meeting with a service dog. The front office staff stops the individual and asks for certification to prove that the dog is actually a service animal. What's the problem?
We are not allowed to ask for any form of certification.
No certification. And just think about it. If we did, do you know how easy it'd be to like hit print? Some like $45 web page, like website, like it wouldn't mean anything even if we did. So we never asked for a certification. That also includes vests. They do not need to be wearing a vest. A community member with a panic disorder shows up to the school board meeting with a service dog. The assistant superintendent tells the individual that the dog cannot be in the boardroom because there are other people attending who are allergic to dogs. What do we do about that?
Allow the dog in and just tell people that there's a dog present and they can move across the room, have to leave, watch on video.
Yeah, so our obligation is to serve both folks with disabilities, right? So if they have a severe allergy and there's a service dog, our obligation is to be, okay, so how can we create the space so that both can be present to the best of your ability? But we don't disallow service dogs because of allergies. That would also be the same in classrooms. If there was a student with an allergy in a classroom, the service dog is still allowed, and we figure out the way to accommodate both. A community member with a panic disorder shows up to the school board meeting with a service dog. The board chair tells the individual the dog cannot be present until the ADA coordinator has met with them and determined the dog is actually necessary. Yeah, and what is the ADA coordinator going to ask? What's your disability? We can't ask that, right? Like, there's no other question that an ADA coordinator is going to ask that we can't already ask of that person. So always err on allowing, and then if you need to do some more investigation into what's really going on, then you can do that. But districts gets really stuck on this, and it's a pretty cut and dry answer.
May I ask what prevents somebody from just saying yes?
Nothing would really prevent them, and they could. If at a time you just realize this animal is not providing any type of service, then that person could, be taken aside and discuss the service animal needs to provide a task or a service. But yeah, there's nothing that prevents them. But the Congress really didn't want that. What they did do, though, is narrow it the scope. So for a while, I don't know if you remember, I remember this. Some lady showed up at the airport with a service peacock. Okay, that's not a service animal. It's not under the ADA, but the ADA did like narrow that scope where it's like, no, we're not having peacocks and snakes as service animals. We don't know what sort like tasks those are performed. It is a dog or a miniature horse, and that's it. So if the bunny rabbit shows up, you don't have to allow it, but it's cute, but you don't have to allow it. Okay, and then this is the new big rule on web accessibility. And so this just passed in 2024, and you will need to be compliant no later than April of 2027 because of the size of your city, the district that you are in. So your IT folks probably are working on this or close to being compliant, but basically all district web pages, mobile apps, have to be completely accessible to folks with disabilities. And I'm thinking about all types of disabilities. So with mobility impairments, if there are issues with dexterity and they can't use a mouse, how are they navigating your website? Vision impairments, when you're uploading your school board meetings and they have hearing impairments, how are they able to listen or know what was being said at the school board meeting? So everything has to be fully accessible, and that's the standard. There is a DOJ fact sheet that kind of outlines that. And for folks, and this might be more interesting for like folks in districts of like the whys and the hows, OCR has a little video series, which is really nice because they're like each 4 minutes long. So you're not devoting a huge amount of time to understand how do we do like color contrasts, right, on a web page, and why is that important? And what is closed captioning? Like, can you do AI closed captioning or not, right? So for a while, OCR was going through district websites to like without a complaint and just dinging districts like throughout the United States and and then requiring compliance. My understanding is that they still could do that. So even though the compliance date isn't until 2026, if they wanted to, they could still ding you now. So the compliance date is just a date that is an expectation that everyone's there by that point, but we should be working towards compliance already anyways. This will gets more challenging when we want to have a lot of cool things on our web pages, and we realize that each time we link a really cool document that's not been checked for accessibility, now we're not compliant. So it's important to make sure that the right folks understand like really cute graphics and is that accessible. And so those are just some things to consider, and that at the district we'll have to work through, as is every other district in the United States, colleges, universities, state agencies, ESDs, we're all going through the same thing. Okay, so I'm going to pause there. That's kind of big picture ADA without going into the nitty-gritty details of the law. Remember, it's a non-discrimination statute, so anything that denies benefit or is discrimination on the basis of disability, like that's what the ADA covers. It just has provisions and specifically for public entities and how that looks for accessibility features and such. But I'll pause there before we jump into some state stuff.
The compliance around the web accessibility is actually a really big issue because my understanding is PDFs don't qualify. So this is actually a lot of work that we're Chloe with DSD has just begun kind of a conversation with me about that we have lots of work to do on this, just so you know that it's a big deal.
Yeah. So we work through our office, we work really hard on accessibility, but it's like if you use Microsoft Office first, do a full accessibility check, then pull it into a PDF, then do another full accessibility check, it may be accessible. Now do that for all 3 or 4 languages that you want that document in, right? Yeah. And then other things like sometimes we want to put surveys and like Google surveys and links to that. Oftentimes those are not accessible. Google tends to not be very fully accessible. So when we start to link on our web pages these really cool things, we have to also make sure that they're accessible for folks. So
Does that mean that that is work that we're contracting out exclusively to WSD? Do we have somebody in district who's
We'll need to have folks in district, and our ability just to push up a PDF. It's really easy right now. And so there's a lot more that we're going to have to, a lot more process we're going to have to put into place as we start thinking about the website and what we're putting on it and how we're doing that. So that's just work out in front of us. It'll be not only Chloe and ESD helping us, but it's going to be here too.
So one last follow-up, is the issue right now more going backwards in time to make all of that compliant, or is it the work to have these processes in place to make it less of a compliance issue every time something's coming up?
So the website's become super stale. And again, with not enough people really working on it. So I think it's a little bit of both, Saul, which is I think there's a bunch of content that we're probably not going to move forward, but there is some. And then there's also the things that we're, as we move forward and we begin to post, we'll also have to figure out, how we're going to get that up there. And we haven't done much of this work. So actually, I just learned a little bit about a process of getting to an accessible document from Miranda. So again, I think there's still a lot of work for us to do here.
Well, and I think about too, like, Booster Club and sports teams that are loading things up into the website and how that's going to need some caretaking.
Yep.
Dave, could I ask you to repeat what you said about PDFs? I just want to make sure I'm clear.
Well, my understanding is I think there's ways to get them to be accessible, but they aren't necessarily right off the bat. And specifically with some of the readers that some of our folks use to be able to accommodate and get to that material, they don't work well. And so we have to do some thinking. And I don't have the answer yet. I just know that it's a problem that we're going to have to figure out.
Okay, got it. I thought I heard you say that PDFs were not a part of the requirement, and as an ODE colleague, I'm like, oh, I'm pretty sure they are. I had one question about program accessibility. In the slide, it said that a public entity shall operate each service, program, or activity so that thing is readily accessible to and usable by individuals with disabilities. So I'm wondering, what are the implications of something like that for a school district, particularly an out-of-school program?
So there is some conflicting information, like especially when we've looked at some case resolutions and lawsuits. But generally speaking, if you have any type of relationship with an organization, whether because you just create the space for them, like, oh, you can use our classroom for free, like, of course, and the main office staff will call the kid in if their mom calls or whatever, like, and they're doing all the services for free, but they're not actually making those services accessible for the students who are using them or for the parents who are calling in. There could be an implication there. Same thing with like thinking about, so one of the cases I was just reading was there was a choir group that wanted to perform at a local museum. And so they went and they got there and there was no ramp. So the mom couldn't see her child perform because she utilized a wheelchair. So she filed a complaint and the district said, okay, we'll work on it. We won't use them anymore then if they're not going to be accessible. But the museum said, actually, we'll become accessible. So you can have us next year. So they did the same thing, except the ramp hadn't been installed yet. And so for the second time, the mom couldn't go to her child's performance. In that case, they were not found to be a program or activity for some reason of the district, but I think in other jurisdictions they would have said yes. So sometimes it's hard to know when it's considered a program or activity of the district. So generally speaking, if we're giving them any type of assistance, whether there's money or a contract or in kind of assistance, we need to assure full accessibility as if they were our own. That also means that if, for example, you had a after school club that used your space for free and excluded students on the autism spectrum because they didn't have the staffing to support them, and there was a discrimination complaint, it would likely be filed against your district. So because it's going to come through the relationship that you have with them, and it would be the claim would be that relationship is discriminatory because they're allowing a nonprofit or an agency to function with us and still discriminate against students with autism. So you just have to be really aware of who you're partnering with, whether you're paying for that or contracting or just kind of in-kind support. So.
You gave an example, and we could get into the wildflowers on a lot of like edge cases, but one that you mentioned earlier was epilepsy.
Mm-hmm.
And I know for a lot of people with epilepsy, strobe lights and that kind of thing can trigger seizures. So does that mean that, for example, if a school had a dance and a strobe light was part of that led to a seizure in the child, that
Well, not necessarily. In that situation, that student would be covered under Section 504, and that would need to be predetermined probably as part of their 504 plan. So we're saying, okay, we know the triggers for this child. It is this thing. Where are there times where there would be strobe lights, and what can we do to reduce the risk for them? And as long as everyone's fulfilling those obligations as part of that plan, it would probably be fine. But if someone ignored that, we're not going to do the strobe light thing because of the 504 plan for the student, then that could constitute discrimination because we'd reduce their access because we were unwilling to change our programs for students for accessibility purposes. So, and that can be anywhere when we talk about programs and activities, we're talking from the bus stop to the board meeting to the prom. Those are all programs and activities of the district.
Thank you.
Yeah. Now, the parent Facebook group that you have no control over, that is not your program or activity, and you don't have to worry about that. Okay. State-specific statutes and rules. So Oregon has its own discrimination prohibited rule and a statute and rule. And discrimination means any act that unreasonably differentiates treatment, intended or unintended, or any act that is fair in form but discriminatory in operation for any of our 10 protected classes. So this is a reason why a complaint can be appealed at the state level, because we have state laws that say this is disallowed. So you cannot discriminate on the basis of age, disability, national origin, race, color, marital status, religion, sex, sexual orientation, or gender identity here in Oregon. And this is for any state-funded schools. So that includes our public charter schools, or even we have some really cool special programs. Those are all encompassed within. And this is kind of gets to that point of, yeah, we can't treat people differently. We can't provide aid and benefit and service in a different manner. We can't deny services. And that E is what we were just talking about. We can't aid or perpetuate discrimination by joining or remaining a member of an agency or organization which discriminates by providing any type of aid or service benefit to them. So we're thinking about like OSAA. We can't be a part of OSAA if they had discriminatory practices, right? So we're always thinking about our partnerships all the time. So these are some examples of disability discrimination. The first one A parent who is deaf wants to attend a school board meeting and request an ASL interpreter. The board indicates that there is not a budget for such services, encourages the parent to watch the recorded meeting, which has closed captioning. So why could that be considered as this? Why would that be maybe potentially discrimination?
We're not providing the service necessary for that person to access everything that somebody else would be able to.
Yeah, so everyone else gets an opportunity to be at the live meeting if they want, right? That's a benefit that is afforded to all community members. And we're saying because of it's a burden to us, we're going to give you an alternative, and it's not your preferred alternative. So the ADA would also say no, the communication request was ASL, not the closed captioning. But Oregon law would also say that's a different treatment on the basis of disability.
But they have to request that in advance,
Yeah, they
right?
can request
So,
it.
okay.
Yeah, because you can't have an ASL interpreter at the weights at every given moment, so they can request it. Yeah. A school district adopts a strict no cell phone policy for students from bell to bell. Sound familiar? The parent of a student with insulin-dependent diabetes requests a modification so that his daughter can use her cell phone for continuous glucose monitoring. The principal denies the request, stating that once one child's allowed a cell phone, it will create a situation where many families will be requesting exemptions from the policy, and which will effectively make the cell phone ban ineffective. When the parent appeals the decision, the school board upholds the principal's decision. So why could that constitute discrimination?
That child most likely has a 504 allowing them all sorts of medical accommodations at school.
Yeah,
This
if
would be
you
one of
need
them.
that device for full access to school, then we modify policy for that student to have access. If there was a different way, if the school wanted to spend a lot of money on a continuous blood glucose monitoring device that notified the parent and you want to spend your money that way, that's fine. Then you don't have to modify the cell phone policy, but probably the easier solution is to modify the policy. So this is only true, however, if it really mitigates discrimination on the basis of disabilities. So if this same student had a different monitoring tool but needed their cell phone just so they could call their parents whenever they wanted to, yeah, that's not discrimination, right? Also within this context, we're always thinking about things on a case-by-case basis. So blanket rules and statements where we say we never do that, I'd be really cautious about that because there's probably always going to be some nuance to that. And I've had many conversations with folks already about the cell phone bans, and they're like, well, how do we tell the other kids why they have a cell phone? I'm like, how do you tell other kids that kids have certain things all the time? Like it happens all the time. There'll be growing pains. It's fine. And kids are used to this. You're used to seeing students that have differing needs. Not everyone has a one-on-one assistant, and we don't have to go around saying, well, they're disabled, so they need a one-on-one assistant. We don't do that. And the same will be true of a cell phone. A school board member uses a wheelchair and needs accessible parking near the boardroom. On multiple occasions, the accessible parking spot has been occupied and used as a loading zone by the district facilities manager. The school board member notifies the superintendent, but the superintendent indicates that it's outside his jurisdiction and suggests they just call the police if it's such a big deal. Don't do that. So those accessible parking spots are there for a reason. We cannot use them for any other purpose. They are often used as loading zones. We see it all the time, and that is disallowed both under the ADA and if that school board member was unable to get to the boardroom because of that, then that's discrimination, right? So we have both a federal and state case here. Okay, so these are associated rules that go along with our non-discrimination requirements. So we have this original one that I was talking through about prohibiting schools from discriminating against individuals on the basis of protected classes. You also have to have your complaint procedures for receiving and resolving complaints of discrimination. And this is where I'll put the plug, is as you're working on your complaints processes and we're talking about web accessibility, those complaint processes on your website better be fully accessible to individuals with disabilities. So if they have to go to a PDF form that is not accessible, then it's not met the requirements under the ADA either. Okay, so it's discriminating on the basis of disability under Oregon law because they don't have, they're unable to access the form, but it's not meeting the ADA standards either because we have to have those accessible. You have to have your notice of non-discrimination on your website and annual notify members of your school community. And you are now required to have a designated civil rights coordinator to oversee compliance with state non-discrimination law. So in Oregon, we passed this law. Maybe that's what I'm getting to. We passed this law to require all public schools and charter schools to designate one or more civil rights coordinators to oversee the implementation of state and federal civil rights laws. And so this civil rights coordinator must have the independence, authority, and knowledge to fulfill their responsibilities. We provide the training, so those folks who are designated, if they want free training, ODE offers that in a virtual, asynchronous or synchronous format. And we go over all the federal laws and state laws and rules that apply for them. One of the reasons the Civil Rights Coordinator Bill passed is because you are required to have a Title IX coordinator. You're required to have a 504 coordinator and ADA coordinator. But there's a federal law that's missing, and that's Title VI. Title VI is our first non-discrimination law that was passed in 1964 that protects race, color, national origin. And we don't have a coordinator requirement for that. So there were a bunch of complaints regarding race discrimination, national origin discrimination, shared ethnic, characteristics discrimination, and nobody really overseeing that process. And with Title IX's new kind of reversal of how they define who they are, what that law protects, sexual orientation and gender identity could also be protected classes that don't have a federal required coordinator. So Oregon now, every school district needs to have someone that oversees all those laws, but maybe are working more closely with those protected classes because they don't necessarily have a federally required coordinator to oversee processes. So the civil rights coordinators must monitor, coordinate, and oversee compliance, ensure the resolution of discrimination complaints, including the remedies, provide guidance to school employees or you or whoever on civil rights law and response to questions, and coordinate efforts to prevent discrimination. But I just want to highlight that this person cannot do this work alone. This person is a coordinator of processes, and there are many folks that need to be at the table. So most likely you have a larger team of individuals that might be working through a discrimination case together. You might have, other equity groups that kind of inform the civil rights coordinator on prevention efforts, and they can kind of work in coordination. So that's just something to be aware of there. So this is your time to locate your own notice of non-discrimination. So I don't think I think the timer is not working. So I'm going to kind of watch. You within 2 minutes should be able to do this. Okay. So you're going to find your notice of non-discrimination or your non-discrimination policy on your website. Find the discrimination complaint procedure, and I want you to find the name of your ADA coordinator and civil rights coordinator in 2 minutes. Go. Yeah. She wins.
I don't see any.
Okay.
I have questions.
Notice of non-discrimination found.
Good. Y'all have 45 more seconds.
Got it? Oh, sorry.
I've got our Civil Rights Title IX coordinator, Tammy.
Mm-hmm.
Our Special Program Section 504 coordinator is listed as Amy Stevens, who is no longer that position, correct? So we'll update that.
Okay. Did
And then-
anyone find the ADA coordinator?
I am not finding ADA coordinator.
So I didn't either. but I did check your website. So one thing to think about is your 504 coordinator also your ADA coordinator? That's fine, but then define that as such. Make sure it's really clear. If you go into your staff handbook, which is online, all different names are listed there. So does that mean that the staff handbook's outdated or which one's right? So I did find an ADA coordinator in the staff handbook, but I couldn't find that person as employed with the district anymore, I think is what I think so, but maybe I'm wrong. I've looked at a lot of district websites. So just you want to make sure that this is something that's not so hard for folks to find. That's kind of the purpose of the exercise, right? How hard is it to find? And would they be able to say, yep, this is the ADA coordinator that I need to contact because somebody, told me I couldn't come to the school with my service dog and I want to resolve that now and not have to file a complaint somewhere else, right? So you want to have that really accessible. The other thing to think about is how accessible all of this information is, both for speakers of other languages and for folks who have disabilities. So once you're doing your website updates and you're getting everything to the accessibility standards, that will probably be really much there. We find a lot of these things. We have to go through a lot of websites, but a lot of times districts have a lot of PDFs of processes that are in English only and not accessible. Yours were a little bit easier to find. They were a little bit more accessible for folks. So just thinking about that. And you should have it available in the languages spoken by your community. So thinking about what languages are in this community. You can tell that by like the churches and the stores and the, community groups that are in Newburgh and Dundee and get a sense of which languages you should be representing on your website. Okay, so we're going to jump really quick into responding to complaints. So just so you know, when a discrimination complaint is filed, it has to be responded to. And not only a filed complaint is a complaint. So oftentimes individuals will make a report in lots of other ways, like an email or a phone call. And those are still considered complaints. So it's fine if they do that and you want them to fill out a form. You just need to direct them on how to do that. So maybe you go, hey, our civil rights coordinator can help you fill out that form. And we had to have to make sure that we're treating all complaints equally. And for some folks, filling out a form is the barrier to filing a complaint. What the district must do if there is discrimination is first, in the discrimination, in the context of disability, that might mean in that denial of access. So we might be sometimes discrimination, we're thinking like discriminatory harassment, using foul language towards an individual based off of their protected class status. But in disability cases, oftentimes this is denial of access. So what can we do to provide access again, right? You might have to fix the harm that was caused. So they lost something in the meantime. How can we give them that back, right? How do we make them whole again? Because that incident of discrimination already occurred. And then we need to make efforts to prevent it from happening. So it's kind of a process. It's not usually a one and done issue. It's okay, we fixed the harm. Now let's monitor and make sure that we're not, our practices and procedures aren't continuing to perpetuate discrimination.
I have a question about that. So the reason we're here tonight, getting your fabulous training, is a circumstance that happened in 2021. And so, I mean, how does that app really apply to the work of the board in terms of, because it takes a long time,
Yeah.
decisions were made, whatever was the context of those 3 meetings in which the board member was unable to participate fully because of not having access.
Mhm. I mean, there's a couple pieces here. One is kind of the theoretical piece of, okay, what do we do from here on out? Like there was harm caused. Let's do what we can to fix it. And what can we do now? What is our procedures moving forward so that we're not waiting for a complaint or us to make a mistake again? We're going to have annual trainings on accessibility, or we're going to have a review once a year on a certain thing. So you can kind of build up your systems to be resilient to those problems. the best that we can do to help that person regain what was lost is important. Sometimes it's nearly impossible, which that the parent that never got to go to that kid's field trip or to the choir, that's really sad because that does happen. And how do you give them those moments back? I don't know a really genuine way to do that, but making efforts towards that is really important. And maybe working with the individual on what that can look like. So if that it was access lost that can't be regained in the exact same way, where can we find that kind of middle ground where the best we can do and what input do they have in that? So I think it's building systems. I think now that you have civil rights coordinator and someone that can maybe oversee some of those processes, they can audit, procedurally, kind of what do we do as a system to help with that and pull in team members to make sure that those are actually occurring. So, but again, it's not like it's a one and done, like that happened, but like from here on out, now we have to continue to work on doing better, right? Yeah. So the other thing I want to say about discrimination complaints is being really excited about local discrimination complaints because they're an opportunity. So if you get a complaint that comes in, and I don't know how much comes to your table as an appeal, if you make the final decision regarding complaints, but when an individual files locally, there are so many opportunities for mending relationships, for creating solutions that support that person or that group and the district, that we don't want to shy people away from actually filing, right? Or talking through that and deciding whether they want to file a formal complaint. It really can, once you get external folks, ODE or OCR or DOJ involved, sometimes nobody's needs are met. It's 3 years down the line and we haven't met that person's needs. The district is getting a resolution agreement that really feels like checkboxy, checkwity, like I like to say. So, taking those opportunities to resolve them at the local level and build alliances with folks who've experienced discrimination and support and regaining access within your systems is really important. So we have all these other options, these appeals processes, these federal agencies, but if they can resolve it here with you all, everyone usually benefits in the long run. And the other piece too is thinking about making that accessible to individuals. So how hard is it to file a complaint? What we don't want to do is exclude folks who have are navigating our educational systems with the most challenges, right? You're going to get the folks who know how to do this stuff and they're going to do it. And they're going to be loud and they're going to file 10 complaints and that's fine. But what you might get is the families that can't navigate those systems very well and they never file that complaint and that kid doesn't have access or that parent doesn't make it to that to those events or what have you. So making it equally accessible to folks who can navigate or don't navigate our systems as fluidly. So a discrimination complaint can only be filed in two ways, either with you or with the federal office, usually OCR, or it could be DOJ if it's an ADA complaint. ODE can only take it on appeal. So if we got a complaint on first instance at ODE, we would kick that complainant back to the district to try to resolve it first. And so that's why those processes can take so long, is by that point, they might be 90 days through your complaint process before they can even appeal to ODE. And if there was an access issue for 90 days, probably more than that, because the complaint might have been something regarding something that happens for 3 months prior to that, that person hasn't had access for months going on years. There's also civil lawsuits, and it's just important to know that the ADA and Section 504 allow an individual to go directly to court. They do not need to exhaust your remedies through a local complaint, through a complaint through a federal agency. They can just file a civil lawsuit. There are two kind of outcomes. One is injunctive relief. So typically that would be like the court orders you to solve the problem. Now you need to make that website accessible. You need to make that building accessible. And oftentimes the district would have to pay that person's attorney's fees along with that. There's also compensatory damages, which is the monies that could be owed to a plaintiff if the discrimination was intentional and that's shown through deliberate indifference. So basically, the district knew that what was happening was discrimination and they were indifferent to it. They could bring that to a civil lawsuit for compensatory damages. And the prevailing party would not only get those compensatory damages, but also probably recover attorney's fees as well. So those are just important things to know. And oftentimes where some of these things start is just a lack of knowledge. So it could be the front office staff that kind of started the whatever issue, and it doesn't get brought up to the right people at the right time, and we didn't train the right people in the right spaces, and suddenly we find ourselves in the middle of a civil lawsuit. So just making sure that your teams all know that all representatives of the district have the same responsibilities for non-discrimination, whether it's a contracted bus driver or an elected school board member. It doesn't matter, right? They have the same responsibilities. So we're trying to update our web pages, but we have more resources now for families and districts. So I just, those are linked there if you go to the PDF. And so if you want to look at some of the resources that are available, those are there. You can also direct families there if you'd want to. But it's just a little more accessible to from the ODE side of things. So before I open up for last minute questions, I just want to remind people that the ADA is a civil rights law and it prohibits public entities, which includes school districts, from discriminating on the basis of disability. The ADA Amendments Act passed in 2008, so we have to understand that that scope of and pool of individuals determined to have a disability broadened at that point, and both under the ADA and Section 504. So we have to understand that disability lives within that definition, even if at the beginning of our careers, we thought about it differently. There are very specific provisions of the ADA that aren't encompassed in other laws that you need to be not necessarily intimately aware of, but make sure that you have the right folks monitoring for that, including accessible buildings, web pages, all those things. And then we have our own Oregon laws that prohibit discrimination and allow us to respond to appeals of discrimination. We are offering webinars for anyone who wants to join. So these are not educator-specific webinars. These are for anybody. So if any of you are interested or you have contacts that would be interested, these are just on very basic topics within the civil rights realm in education. So just overviews all the way through specific federal laws and state requirements. So those we want to keep open to all community members if you want to share those links. And then we do have a unified email address. So if you have any questions regarding any civil rights concerns or just whatever, that will get you to the right folks within the agency. So with that said, I will open up for any questions that you may have and then let you all take your.
I don't have a question, but I want to say thank you for your time and going through this. I learned things. I had questions about the other part of the aspects of law and our relationships, et cetera, and just still learned it here. More of a comment though towards the board, because some of our printouts missed the email or whatever, right? So I just checked on our board packet, all the links work and everything's filled out in the board packet. So if you really want, because I saw you writing, I wrote down stuff that was missing, right? It's all there and all the links work. I clicked a few, so.
Well, I appreciate your time and coming out. You did a really good job of succinctly, condensing a lot of really important information. And it looks like we've got a lot of work to do with our website.
Yeah, I'll also say that Tammy just redid the staff handbook, so the new one isn't up yet. We're working on the student rights and responsibilities. I was actually surprised that some of the new folks who will be taking over in a couple of weeks when staff report, they're there. There's some pieces that we need to fix there, but yeah, there's some work on the website. Not having a communications director for the last year, I think, has been a little harmful to our process, but I was actually surprised at some of it's already updated, which is good news for us, but we'll get working on that.
Okay, any,
I'm just curious if our teachers and staff also take related training. There's just a lot in here that I didn't know, and I've been in different public spaces that this would have been very helpful to have known.
Yeah, so every year, all of our staff go through a series of training over the years. Since 1990, those trainings have become very extensive, and civil rights is one of those trainings, along with a whole series of different things. We just met today talking through the vector trainings that our staff will go through. But it's always something that's we're thinking about. I mean, this is a primary function of schools is how do we provide access, not only to our students who qualify for disabilities, but for all sorts of folks. So, and I'll also say some of what happened should have never happened. Like we don't need, I don't need training to understand that access. I mean, I appreciate the training. Don't let me say it like that. But again, some of these things should have never happened. That's just not how we work. So I don't know. That was more than you wanted, I'm sure.
no, I appreciate that comment.
Yeah.
Rebecca, would you like to come up and join us? And if you and Jean want to come over and sit over here on this left-hand side or your right-hand side, that would be great. And just a reminder to please turn on your microphone. Maybe introduce yourself just for the record, for when people watch this in 20 years and are curious.
Promise not to be as long as I was before.
You have all the time you need.
It's on. Is it on?
The mic's on.
Okay.
Yes, your mic.
I just want to take a moment to thank the board for considering, for educating yourselves and being aware of the situation. Sorry. That's what you get for having a talking phone.
And an assistant.
Yeah. Just
There you go.
yeah. Okay. It's been 3 years since I resigned from the board. It was 3 years ago in May when I submitted a complaint to the board. And then in June 28th of 2022, the board rejected my complaint and said it had no validity. And I was thinking about the question that was asked, well, what part of the board's responsibility do we have in this regard? I think your responsibility is to educate yourself as you have tonight, to have compassion for people who are different, and to be willing to ask the questions, how can I help you? Dave Parker was assistant superintendent in 2017 when I wanted to return back to the high school to work. And he was very willing, even though he asked the question, well, what can a blind person do? To me, that he was so open to having me come back. That was so encouraging. And then when I became a member of the board, Dr. Morlock asked me, what can I do to make your job possible? And just asking those questions that to get a better understanding of people where we are at, and the compassion that was lacking prior to previous situations. I'm just so thankful for the board's new direction and for the light that's coming back to Newburgh. And I'm thankful for the Oregon Department of Education for taking up my appeal and and working with us through this reconciliation. It feels like the one last thing I could do for Newburgh School District. And I'm very proud to have been part of this, and thank you very much. I also, I'm still a volunteer at Newburgh School District, and I am open to coming to classrooms to talk about blindness. I think educating young children, I've been to kindergarten, first grade classes, fifth grade classes, middle school and high school health classes on my disability. It brings us together and shows that we can add to each other's lives so much. And I think the actions you're taking now will help make sure that no other student, no other staff member, no other board member or community member will experience what I experience. And I thank you very, very much for this opportunity.
Well, I am going to get a little teary-eyed. You have given so much to this community. And I just thank you so much for all that you've given and your compassion that continues. You are the shining light for our community. And thanks for your dedication to the board and your continued dedication to our students.
Thank you.
I just want to say that I really appreciate that you didn't let the situation be what it was, that you made sure that it was known that it wasn't okay, that there's things that we all need to learn, even people who may be more compassionate or more willing to do those things, but to not let mediocrity be the answer, to make sure that we are learning, that we're growing as a district, as a community. So I really appreciate that you stood up for what you know is right, not just for you, but for everyone. So thank you so much.
Thank you.
I'll just add, of course, Rebecca Pyros, you would bring this back to students. You've always done that. And so while you are here because of something hard that happened to you in this community, the fact that you took this right back to students is such a testament to who you are. So thank you for being here. Thank you for being light in our community.
Thank you.
Okay, well, I think that this is probably a good time to take a break. And then we'll come back and get to the other portions of the agenda. So thank you so much for your time and your experience and your knowledge and making this a very interesting presentation. And thank you to the Pryoroses for being here, as always. Okay, we'll take a 5-minute break. Okay, we are returning from our brief break and moving into the next step of our agenda. And Holly, you are up to talk to us about some policy.
Good evening, everyone. Last spring, specifically April 15th, we had an AI work group gather for the first time. It was comprised of almost exclusively secondary teachers and admin to talk about the latest tech wave in education, which is AI, and it is so much more than tech at this point. But we gathered to talk about the two facing conundrums, which is staff use of AI as well as student use of AI. And what does that look like? So we used exemplars from McMinnville, from Tucker-Tualatin, and just looked at how are other school districts approaching this wave of change. And in that meeting, we drafted an initial policy off of a recommended policy draft from the Oregon Association of School Boards. And we made some changes that made sense to us and our practice, not only as colleagues, but also as practitioners with students in mind. That group then took back the draft policy to their buildings to collect feedback from their fellow colleagues. And then we gathered again on May 7th. And this is the result that you have in front of you. So again, very much guided by the policy exemplar that was shared with us from the state. A couple of additions and refinement from what we know to be true here in Newburgh-Dundee Public Schools. And so you'll see that represented really well in how we're trying to confront not only staff use and our absolute need for privacy and how to manage that well as how to guide students to use this very valuable tool at the same time and give teachers that gatekeeping possibility of what is used and what is not used within their learning cycles and teaching approaches. So any questions about that process?
Yeah, I have a couple questions. So this,
Yeah.
OSBA actually has a sample of this policy.
Yeah.
Okay. For next round, when we actually approve this, can we have that sample and understand the differences?
Absolutely.
Okay.
Mhm.
Then two, I know this is a little outside of our scope because we're really only on the policy side. But I would love to understand, and again, it doesn't have to be today, it could be a future presentation or whatever, like what are the tools that teachers or administration has to combat AI or overuse or I know there's a couple I'm drawing a blank. Yes, it is. If it's not pirating, that's music and videos. What?
Plagiarism.
Yes,
Yeah.
there we go. Plagiarism. I knew it was a P. So. But like I know there's other plagiarism tools in the past. I'm sure
Right.
they even now have scoped over into AI. Are we just using certain tools? Or like I guess what do we have at our expense from a teacher administration level?
Absolutely. And if we want to dive into that further, we can. I will tell you that we are looking at the use of this particular policy for only a year. Because like anything else, even the tools that we have with all the vetting tools within them to identify where students have used AI heavily or it is truly plagiarism at that point, and not just ideation, and they're using that as a starting point of their thinking and creating, they're going to be already outdated within a matter of months. So it is just a slippery fish that we're working with. And we kind of know that, just how rapidly tech advances. Just to give you some scenarios that scare all of us. Our alternative learning platform of COA programming is all online at our 6-12 grade bands. It is so wonderful for students and who need that approach and need that flexibility, or they're going through some life experiences where that just makes school work for them in that approach. The problem is that our students are so savvy with what exists in the online world that you can go and you can get a bot that impersonates you and does all of your learning and work for you. And it's just an AI program that now students know how to use so well. So one of the major changes for us to consider is when we as educators require by hand and on-demand work, so that we can verify that that is that student's learning. And it doesn't mean that we're not doing things online. Of course, like we're equipping our students for life, and life is so much online or using these AI tools. Just as point of information, lots of different high schools are now providing a class on how to use AI. So it is overwhelmingly a tool to be used to help kids guide in decision making and ethical practices. This is just another way to live, and we'll teach through that. But exactly what you're asking will change in 4 weeks, 4 months, and that's tough for us.
So I get it. I live in the tech world.
Yeah.
I work with software developers, so I get it.
Yeah.
And it, I think I might be quoting somebody somewhere, but we thought spell check was,
Yeah.
a tool that was supposed to be prohibited way back in the day, right?
Right.
So,
Right.
I get it. Thank you.
Yeah, absolutely.
Yeah.
Yeah.
That too.
I'm curious the process or a list of how are we deciding what AI tools are safe and useful, and how is that process going?
Great question. So we'll have a general list that's developed between our tech department and us, and they basically do the vetting for safety on that side of the tech world, and then we'll share that list with our educators. The educators get to decide within their classroom what is used from that list and what is not. But AI is now embedded into so many things. So whether we're talking about Grammarly or we're talking about a Google search, AI is at use and all that. And even some of our instructional platforms are utilizing AI as part of the platform we're paying for. So it gets tricky when we have to identify everything. So some things will be described in broad strokes of what we already have, while others will be very identifiable by the actual program. And again, that will be shared with teachers. And then teachers decide as gatekeepers what's used in their classroom and not.
So the other question I have, and it almost feels like the problem with trying to write a policy like the FERPA and confidentiality. Obviously, you have that in there. Don't put that information in here. What do we? It feels to me like it just is going to happen. There's no way you get around certain things. I have my own thoughts on AI and like the medical field, because there's so many things where you have student input, and when their name goes in, when information goes in, do we have any way that we can control that, if that makes sense?
I think this burden rests not only within our processes and how we train our staff around what we know to be true of what we know people will be using, and also anonymity. How do we ensure that nothing is identifiable within any of the things that we're putting in AI and expecting that output from? But there's a lot of guidance that's going to also be resting with our tech department, because they know infinitely more than I do about so much of this AI complex world. So I think it's all of those things in tandem. As soon as we know something to be true of a process, that we turn around and we train our staff well of what we do and what we don't do in utilizing a tool. But definitely, I mean, it's a blanket statement. You'll see in the policy that our top priority is safety and security when we're using any of these tools.
One last question.
Sure.
Is there anything specific that you could say that having this policy is going to change the practice of in the classroom? Or is it just saying what is already happening and outlining that?
Oh, good question. If you were to ask our work group, this is actually still relatively new to teaching. So we're actually putting in some safeguards and parameters first, rather than crazy blanket use across our district. That's actually not occurring, but they are encountering, even on the teaching preparation side, what do we do? It is an amazing time-saving tool if you know how to use it well. If you know how to take that and morph that to your students sitting in the classroom. But when it comes to student use, as always, we're behind what our students have been doing. And so we are playing a catch-up game. And actually, I don't mind that. Kudos to those students who are the early adopters and gunning ahead. They are exhibiting skills in this world that you get paid really well to do. But we have to also ensure that we are having our students learn. They are learning and not deferring their learning to a tool that they can readily access. So that's our work, is to make sure that the learning the student needs to have within each grade level happens for them and not by accessing an online tool. But like calculators are a great example. If our students know the process, they know what they're looking for, they already have a self-check in their mind, they know that answer can't be correct because they know these math facts in their heads. But yet they use the calculator because the process is so much faster. AI is similar in some regards, but then it's not in others. So we have a lot of work to do.
Thank you for this. I am continually fascinated by AI in education and just the roller coaster that we are all on there. Do we have any hopes, dreams, plans, bandwidth for possibly teaching explicitly at the middle or high or honestly elementary level some of this AI literacy and
Yeah, I believe that that's coming, but we're going to cover graduation requirements next, and we'll see how that is complicated because just even articulating time away from our current programming for adding another class is rough. However, I have full faith in our teachers. Our teachers know how to equip students, and we have some phenomenal teachers who are already embracing how do I make this accessible to my students? How do I teach ethical situations with my students utilizing AI in any of these ways? So we do not have a plan right now for this is the class, but we started last fall. 2 amazing professors at George Fox walked our secondary teachers through AI tools that are available to them and just AI in education in general. And I think that got them sparked into what do we need to start embedding into our class. This policy helps to define for them what they can stop students from doing because they know their learning process needs to not include AI for these pieces of the education within a class. But it does give them the permission to use it, teach them how to use it. Yeah. The one thing I will say, unintended beautiful benefit, which is in tandem with this conversation of the American Disabilities Act. There is so much accessibility now by using AI tools, whether it's changing something to a reading level that you need, whether it is changing XYZ of a particular tool that students are using. So as a practitioner, I get really excited because, oh my goodness, now this and this and this is accessible. But with that comes, did we think through the unintended consequences of relying on something too much? Yeah, so. Any other?
Holly, thank you for the overview. I just want to name that I greatly appreciate the collaborative approach to developing the policy. I will say that my initial instinct when I read it is this doesn't look like some of our other policies. And so I'm eager to really dig in. One of the things that I guess it feels in some ways a little too detailed for what we would normally see as a policy. However, one of the things that my eyes go to are anytime I see the words must, may, should, can, cannot. And I do have a concern about the last line on the first page, what is page 51 of the packet, in the section where it talks about specific rules for independent use. And I think Dr. Peters spoke to this a little bit in the OCR presentation. It says failure to follow these rules will lead to an incomplete or no credit given. To me, that seems, I mean, I understand that, right? But that's saying there are no edge cases, there are no nuances, and it feels like maybe that should say may.
That was a huge piece from our educators. It didn't say that originally. They wanted it to be clear that in all the ways that you can use this tool, if something is prohibited, it is prohibited. You do get a referral for going outside the boundaries of that. I believe that the balance of that, and I can't remember where in the policy, we talked about in collaboration with a teacher, having a discussion for student use. But if we need to expand on that really clearly, that that's where the give is in those case-by-case conversations for student use with a teacher, but you have to understand, and this is what I think they were trying to capture, and maybe they didn't do it well. So by all means, please give the feedback. I think that they want it to be clear. It is very easy to sidestep a parameter or something that they are not allowed to do and say, but I need this way. That is a conversation to have, but there has to be agreement with your instructor on that use. And so it is a very fine line. So we either counterbalance that again with making it really clear that case by case situations could be discussed with their teachers or a teaching group. And if we need to completely remove that so we don't create a problem, we'll have to look at that. But I want to speak up for our teachers. They were very adamant because this is a classroom changing environment that their gatekeeping for the learning experiences they're trying to create itself are protected and some things are prohibited. So it's a fine line.
That's really helpful to understand. The way it reads right now is if I, as a student, fail to identify or attribute within my work where I've used AI, I automatically fail the course.
Well,
And
so
to
think
me,
of the
that-
scope of our courses. Some are totally online. Some are very few assignments that turned in as your summative work. That's where the grade rests. Like 80% of your work is summative work. And again, this is dependent on the class. But if that was a type of activity that could be heavily influenced by AI, I think that's what they're trying to represent very clearly. You can't expect to pass the class if you haven't done the work. And so a bot hasn't done the work in your name. There's so many things they're trying to capture there. But again, feedback will be gladly received.
I really appreciate that.
Yes.
Two other things really quickly. In the staff professional development, it says the district will provide professional development opportunities for staff. Just, knowing the broader context of our funding situation and
Yeah.
the calendar that we're going to talk about later, can you speak a little bit to what those opportunities will
Oh, I
look
can
like?
speak really specifically to that. Like I said, secondary last year already began receiving PD in our in-service week. And this year we're making it more focused to the universal design of learning, specifically those instructional practices. How do we make learning accessible for all students in our classroom with AI tools? So they're going to get explicit training and support of the approaches we're trying to put in place in all of our classrooms, 6-12, and then what are the AI tools that support that. Simultaneous to that, our K-5 group will be receiving explicit instruction of what we're looking at with small group instruction. They're going to basically look at our process of small group instruction at that time, but we'll also be extending, these are the tools, the AI tools that could help you set that up in your classroom. It won't be within that training, but they need that training first, and then the tools that would support that work later.
Is that primarily coming from within? Like, is there, it's probably a both and, but I'm guessing like there's
It's definitely going to be a both and, but our presenter on UDL is actually coming to us from Chicago. Very well regarded within a greater organization called Learning Tree, which is in tandem with our PLC training for our admin. And then like I mentioned before, 2 professors from George Fox had offered the previous AI instruction and guidance.
Great, thank you.
Absolutely.
Last question. I know we'll also be talking about a contract later today. Did the work group bring up any specific concerns about workload?
Not really. But again, remember that this is, in all of our opinions, this is for a year. Because we just don't know what we don't know. And most of the discussions around AI tool use is time saving. So we just don't know what we don't know. There's some assumptions made in what this will and will not do, not only for staff, but for students. So we have to give it a year and see what comes of it.
Thank you.
So should this policy indicate the length of the policy?
I don't know. I mean, it's a policy, right? If it's elastic enough and it holds true and it holds water for a year, it might not be worth.
Okay, so really, I think what I'm hearing you say is it's going to be revisited in a year and could look at some revisions. One thing that I want to add is it would be very fun if sometime in the year we could hear some examples of how students are utilizing AI in an exciting, dynamic way. So that might be a really fun thing to have at a, a meeting.
I have, I'll try to be brief. A follow-up to the professional development question from Andy. So in the independent student use rule number 3, the teacher's ability to detect usage accurately and consistently, that is an area that I've had personal experience with where it is so varied. There's so many programs out there, many of which are paid subscription sort of programs. I've sat in many rooms where teachers will have very different opinions on whether or not we think, AI was used. It is a very gray area. And I'm curious if we have a service that we are maybe going to try out this year or whatever that process looks like. And it doesn't have to be a clear answer now, but just I would love to hear about that. At the end of the year of what did we find worked well for us?
I will just let you know because it's too long of an answer for right now. But our 2 programs are the Google Classroom Suite, where we utilize Google Documents, already has a built-in filter, as does Edgenuity, which is the platform we use for our online learning, has their own. And I will tell you that because AI use is so rampant now, it's flagging even quotes that a student has identify it as a quote in their writing, but it's just looking for those patterns like crazy. So it doesn't mean like the work is done. Teachers are still having to scrutinize student work. But yeah, those are already built in at this point. Do we need more? We don't know.
Thank you.
Yep.
I'm going to propose something. I'm directing this question to the policy committee because I believe you were presented this via email, and at that point, maybe jot down your notes, bring them here to talk about. And the 3 of you have asked most of the questions. Not having the OSBA sample plus all the questions that you've already addressed, does this need to go back through the committee officially and to actually have a discussion to talk about and address all your concerns?
Probably. I think one of my biggest questions is what separates this as policy rather than like a student handbook thing. Like there is no policy on plagiarism. There is no policy on any other, like I'm looking at the instruction, the eyes, and it doesn't feel like this fits in the same way as policy. It seems like this is how it's going to be run in the classroom. This is what's going to be happening at your school. To Director Briley's point, it's set up in a way where it explains a lot of things for us. I'm trying to find the policy part of it rather than the direction for the classroom, the direction for students, for teachers, and just separating that out, if that makes any sense.
Well, I mean, my initial thought, which I can see that Tammy wants to also say something. My initial thought is it's a new wave of change, and policy is to have a common understanding, correct? An understanding of staff utilizing something, students utilizing something, but it goes beyond just instruction. It is trying to provide some parameters. And again, on a very slippery fish of a whole new world called AI. So I don't know how to better answer that question other than we're also following the recommendation to have one in place from other school districts and from this state.
Yeah, OSBA has policy on this. So I think the suggestion that it goes back to the policy committee, that's fine.
Yeah.
If that's what the board wants right now, we can send it back through there and we can take a look at some of the questions you've answered here. But again, with something this major, I think we need policy on it. I don't think it's just a handbook piece. And it's new and emerging. And I also spent some time recently with a recent graduate, and we got to talking about this. And it was really interesting because he actually utilized it in a really effective way around developing study questions and about the way in which he was using AI and how to help him actually not cheat, but actually study and learn. So I think we do need some policy around this. Truthfully, we were trying to get this in before the school year started. But if you wanted to go back to the policy committee, it's fine. It's like, let's do that. It's going to take another week or two. I mean, we'll probably set up a special meeting for this one because it is kind of time sensitive. But really, if that's what we want to do, just say the word and we'll do that.
Well, that's my recommendation. It sounds like it might need a bit, and I agree with Director Allen that some of this sounds more AR-ish versus policy-ish, and I think we need to kind of delineate the differences. So.
Is that where everybody else? I mean, it's a report. I mean, we're just presenting right now anyway. I see lots of nodding. So, okay, I'll set that up to go back to the policy committee and we can sit down and take a look at that.
Thanks for your questions. Super helpful.
Well, and thanks for all the work on it. I
Yeah.
mean, it's really interesting. It's very emergent, but it's out there and kids are going to figure it out well before we do. And people who want to use it for not for good will figure that out even faster. So, okay, so let's hear about IKF.
Okay, IKF just had minimal updates. It's the requirements for graduation. This was vetted by TNL, so both Jillian and myself, as well as Dana and our SPED director, looking at all that was there. The biggest change for you guys to note is the addition of the 0.5 higher ed and career exploration at the high school level, as well as a 0.5 financial literacy. Those are with the additional credits of social studies, now the 3.5 credits in our social sciences department that a kid must meet in order to graduate. It also had some more clarity around the modified diploma, which Dana vetted completely. And so you're seeing the most final draft for us, but it fully is all the language of ODE essentially within our own policy.
The modified, is that specifically for special ed students, or is that actually the difference between Oregon diploma and Newberg diploma?
No, that is specific to SPED.
Okay.
Mhm.
You know, anybody have questions about this one? Okay.
I don't have a question about this one. I do have a just general question of how do we introduce potential policies we want the policy committee to look at? Outside the long list of
Well, that's what I was gonna say. Just send me an email. And
Just-
add it to
yeah.
the list, because
Because there's only 500 and some.
there's such a
But
long list.
there is some, obviously, you know, there might be some priorities on some of them.
Yeah.
So I would recommend sending it to Dave and.
Yeah, if there's
wanted
something.
it official. So
Yeah, I know, that'd be great.
Okay.
The other issue that we need to do is really set down a calendar. So again, this meeting around the AI policy will also give us a chance to sit down and crank out like what days, when are we bringing things back? And I know it's one of the projects that Tabitha is still working on is kind of to get all of that organized, because it's a very big list of things to try and get organized. So yeah, send it to me and we'll get it added into the list. Yeah.
I will send an email to remind you though.
Thanks.
Okay, thank you very much.
Thank you, guys.
Okay, Nate, you want to talk to us about taxes and
I'd love to.
RFPs?
Start with taxes. Just a brief review of construction excise tax since Celeste wasn't here last time we went over this. So construction excise tax began in 2000, was passed in 2007, that allows us to levy taxes against new developments. Originally, it was set at $1 per square foot. And in 2009, those rates became indexed, and the Department of Revenue establishes the rate increase each year. However, in Newberg, we haven't updated the rate since we implemented in 2009. So we've been levying $1. Well, it's not a levy, I'm sorry. We've been having that tax added to construction permits at $1 per square foot since that time. And I have the presentation here for you if you want to see it later. So what we want to do is we want to come up to the indexed rates, and then each July, the state puts out the rates for the following year. So we've actually gotten that since we originally talked about this. And so we're able to identify those index rates in the resolution. And then just as a point of context, with this new rates, I look back just to the last 2 years, and if we had been using indexed rates, we would have had a little over $250,000 more dollars over the last 2 years. But since they're not indexed, we didn't get that. So what's in your packet, it's a little bit out of order, but the first page on 63 is the index rates that we get from the state, from the Department of Revenue. Page 64 is the cover page that has the recommendation at the bottom. And then page 65 is the actual resolution that we'll use to share with the city and counties for establishing those rates.
And Nate, can you remind folks what we can spend construction excise tax on?
Yes, we can spend this on acquisition of land, equipment, furnishings, or other tangible property, other assets with a useful life of greater than a year, construction improvement of school facilities, related professional services, and obligations and costs of issuance, could be a bond or lending for those purposes. So school-based expenses only, so we couldn't apply it to this office. As an example. Thank you. Good question.
So this is resolution 2605. The resolution is 20.
So no, yeah. So we were going to do this in June, and so the resolution should be 2026-05.
Okay, and so then on the resolution that I'll sign, we need to just change the at the top.
Yep.
Do we need to read this resolution into the record?
No.
Or just because, okay.
Yeah. So when your recommendation says by title only,
Oh.
that means you don't have to read the whole resolution.
But so, point of clarity, the 25-26 will go into effect as soon as today if we approve and sign.
Correct.
And then 26-27 is that now therefore be resolved that years beginning July 1st of 2026, the tax rate still in the resolution shall be indexed to the inflation determined, right?
Correct.
Okay.
Correct.
Just want to make sure. Okay.
I move that the Newburgh Dundee Public Schools Board of Directors approve Resolution 2026-05 to revise the construction excise tax rates to match the Oregon Department of Revenue index taxable rates for 25-26 and 26-27 by title only.
Second.
Any further questions? I'll call for the vote. All in favor, say aye. Aye.
Yeah.
Motion carries unanimously. Did you say aye? Okay. Okay.
I've said it in my mind.
Okay, perfect. Okay, aye. Okay, wonderful. Thank you.
Thank you. All right, the next one, approve the contract award to Spring Valley Dairy. Our board policy says that any contract over $100,000 a year, the board will operate as local contract review board to approve that contract. This was a cooperative contract between 12 districts to get fresh dairy products, and we participated in that cooperative. And Spring Valley Dairy, who is our current provider, was the sole respondent to that RFP. And they, after going through the scoring, they scored 90 out of a possible 100 points, and are identified as the awardee for that.
I know this is the only one and we should prove it, but like, do you know what the cost, was there an increase from last year to this year or last contract to this contract?
It's hard to say because it's based on participation. So we're just looking at last year's participation numbers
Gotcha.
to identify this amount. This is about 10% higher than what we anticipate, what we paid last year.
Okay.
This projected amount.
Do you know where Spring Valley Dairy is?
I could find out.
I can Google it.
Yeah.
My assistant here could
I
Google.
was going to say, who has AI? Who has AI up? Salem. There you go.
I move that the Newburgh Dundee School Board District Board of Directors approve the RFP contract award to Spring Valley Dairy for the 2025-26 and up to 4 subsequent years as presented.
Second?
Any further questions?
I do. Is it? I guess it just seems interesting that only for milk we're having this conversation. Is it
Dairy products.
dairy products?
Yes.
Excuse me.
Fresh dairy products.
I guess it's just interesting that it's not for other,
Yogurt.
well, other foods, other.
Yeah, we have separate contracts for depending on where the food is coming from. So our wholesale distributor is through like Cisco. Fruit and vegetable can be through Charlie's Produce, for example. We also get produce through Department of Defense contract, United Salad. So there's, depending on where we can get the best pricing, we have separate contracts for different.
And so the dairy hits a certain amount that brings it to us where other ones wouldn't.
Or it was approved in a prior year
Okay.
because they're 5-year contracts.
Thank you.
Yeah.
Any further questions?
Just would like to thank them for their milk because my children drink a lot of it, including the chocolate milk. My kids had a competition to make sure they could each consume a chocolate milk every day, and they succeeded last year. So
Oh,
thank you,
That-
Spring Valley Dairy.
Right?
look at that, applying themselves. Okay, we'll call for the vote. All in favor, say aye. Aye. Motion carries unanimously.
Thank you.
Tammy, you're up.
All right, so I've provided you with 85-ish pages of light reading. This actually is the draft for our contract agreement between Newburgh Education Association and Newburgh Dundee Public Schools. We met several times throughout the late spring. It felt a little bit truncated. I don't know if it felt the same way for others, but we waited so that we had a better idea of where we were going to come in budget wise and what we could work with. But then it ended up being a really productive negotiation session. It felt very collaborative between the two parties, and we were able to put in a couple of long days and actually get the contract agreed upon prior to July 1st. And I think that was, again, a testament to the collaboration and a desire to have a contract in place by the time teachers came back this fall. So what I did is I provided for folks just a summary of some of the major changes that we agreed upon. And so happy to answer any questions related to those.
On the Article 12, in-district interviews per building to 2 a year. Could you explain that?
Sure. So when we have openings in district buildings, folks in our current school district are able to apply for those. So inter-district, applications. If someone applies for a job and doesn't get it, applies for a job again, the same building doesn't get it, applies again and again, we're having the same interviews. Really what we were trying to do is set a precedent for if someone applies for a job in a specific building and doesn't get that job, that there is specific feedback to that person and conversations. And I don't know that we were completely confident that was always happening. So we thought we wrote in there that we needed some specific feedback for folks and then limiting those applicants to 2 per year with that feedback given would suffice for opportunities for people to apply for jobs within specific buildings, at least for that year.
Thank you. That's super helpful.
Now, if they're chosen by the screening committee, that's still, they can do that.
Mhm.
It's the automatic interview that's limited to 2.
And that's based on the school they're trying to apply for?
Correct.
Towards? Okay.
I guess what's the difference between the automatic interview and the
Well, again, there are screening committees that go through the paperwork and look at the folks. Our contract says we will interview every in-person applicant. That's what we're limiting, is that automatic. Screening committees still have the total ability to look through and choose the candidates that they want to interview. And if it was the 3rd time, but that screening committee wanted that person, then that happens. It's really about the automatic interview.
Correct. Yeah, there's language indicating that we will. And so we just added some qualifiers, and we also added some language to ensure that feedback was given.
What was the last contract? Was it wide open still?
Wide open.
So I'm assuming either the district office or the administration had the feedback to try to narrow it down. Is that where it came from?
Again, I think the conversation really came back to, in these situations, we need to provide feedback.
Sure.
And so people need to understand what they're doing well and what they might not be doing well in these interview situations. I think that was the major focus. But there was another part here where, if it's your 5th time interviewing this person inside the building, that seems counterproductive. So that was but the conversation was mostly about, how do we provide feedback to the employees about what's going well and what's not?
Is that where it's under number 4 of that same D4? Members requesting transfer will be given notification of approval or disapproval of the request. Is that what's supposed to be addressing that?
That's a little bit different. Those are for voluntary transfers. Yeah,
I had the same question, Saul. So
great question.
Good.
You'll notice the majority of the changes, a lot of conversations around salaries, benefits, some language, just to point out some language to provide better support. For example, our counselors, a recognition from the district that counselor caseloads and responsibilities have increased, and as such, an opportunity to converse with counselors if they need some additional release time. Added the extra duty. We wanted to make sure that there was equitable compensation for everyone who has to enter postseason, and that's inclusive of our pep band director. So we wanted to make sure he was compensated as well.
On Article 30, the language for building discipline plans, at what point does that, not necessarily come back to us, but I feel like that's been something that we've kind of talked about, trying to have a better understanding of what's going on with those. And I guess how does that change, adding the fall labor management? What does that entail, I guess?
Yeah, so there were some extensive conversations around Article 30, and as you had kind of mentioned, some issues that have been brought up to the board, especially in regards to some students who have escalated, and what that looks like. So I think what these language changes capture is just collaboration between the union, and the district in terms of what discipline plans look like within the building, what communication is transpiring between administrators and teachers, and specifically teachers maybe who have experienced physical violence from a student, ensuring that there are some agreements about what follow-up looks like and what the discipline plan is for that particular student. So it's really just creating some language to open up, ensure that there's some conversations happening, and that there's a plan of support for staff who have experienced some physical violence.
In that case, did you say it becomes an individual case by case, or is it more this higher level building? This is what we do.
So that's really captured in our discipline policies and in our student rights and responsibilities. We do have discipline matrices, and so globally that's what we use. But we're talking about issues where students have somehow harmed a teacher, and we have to put a plan in place to ensure that student can still get access to their education, be in the classroom, but that we support and protect our teachers as well.
I think our conversation with the union really kind of came down to this issue of student misbehavior in class. And they were looking for more restrictive measures. And we felt like actually we have language in our contract to deal with this. It's just that we're not very aligned across the district. So part of this conversation was about making sure that everyone has a building discipline plan and that we're communicating that plan to staff. And some of that language is already built into this contract. So a lot of what we're trying to do right now is, again, kind of align practices across the district that may have fallen off over the years. And so that's the nature of the conversation between the union and us, is them wanting to make sure that the union members have recourse and are protected, and that we have systems that are solid in trying to protect them and the students. I don't know if that.
No, that's
Yep.
great. Yep.
Man, Director Allen and I are really on sync on what we're pointing at today. So I just want to make sure it's clear, and maybe either of you could expand on this. Even as those building discipline policies, I'm assuming that the same policies or the same. It's like all elementary schools should have similar policies, right? Like the one is not different than the other, and like the secondary levels, right? It should be the same.
Same is a tough word for me,
Okay.
because of every discipline event is slightly different. But we should have similar policies so that kids who are having physical altercations in one school are being dealt with basically the same between the two. Today we met with principals to begin to talk about kind of some discipline matrices where we align some of these practices. But I can give you every single discipline event is slightly different, and we have to take into account some of these changes in how we apply our discipline. The building plans, and that's why we have a district student rights and responsibility. Tammy has just revamped it because there wasn't one last year, and but we haven't revamped. We presented it to principals today in our admin meeting. And so we're beginning to align some of those practices. But there's also kind of some building practice. Buildings have different shapes. There's different hallways. And so like how you actually get an administrator's attention, how you walk a student, some of those things could be different from building to building, which is why we have a building plan. Now, they should be taken into account kind of the overall piece. But I will say that we're not consistent across the district with those building plans, and the knowledge of teachers of how to access that help. That's also not consistent. And that's one of the things that we're working on is to get that. And it's what the union really was wanting, is like, hey, when we need help, we need to make sure that it's being given and we know how to access it.
Exactly what I want to hear, and I love it. Thank you.
Do we have any further questions?
I do. I don't know why my eyes are like drawn to the really arcane details. However, I read something and made me go back through my notes from the OSBA summer board conference. On page 6, where it talks about the definition of a contract member, any member who has been regularly employed by the school district for a probationary period of 3 successive years. There was actually legislation passed that changed that for folks who have already done those 3 probationary years in another district. That reduces it to 2 if they were to transfer here. So I wanted to flag that in case that needed to somehow get reflected, and I'm not a lawyer, but
So yeah, I mean, the state law trumps policy. But let's take a look at that and we'll work through that with our union. But good call.
eagle eye, I don't know.
Yeah.
The summary, Tammy, was really helpful.
Okay.
Thank you very much.
You're welcome.
Okay, so procedurally, since it looks like that contract member needs to be looked at or revised.
Yeah, let me be clear. This is in draft form. I think we could
Okay.
still move to approve this.
Okay.
I actually spoke with my union president this afternoon, with the understanding that we may have some small edits to make on this. For example, the issue that Andy brought up, we didn't even bring this article up either side for conversation or negotiation this year. So those types of things will still be fixed. So you can choose to move forward with approval should you choose to do so.
Okay.
With the understanding that we'll continue to work on those minor nuances.
But hold on. So when we approve stuff, it either needs to be as amended as we're recommending it, unless you two are going to negotiate with the union and have a different worded change. Then I don't think we can approve it unless we approve and then come back with.
No, we just come back with an MOU.
Okay.
To change that specific piece.
Right. Okay. I'm fine with that too. So.
Okay. Okay. Are we ready to have somebody make a motion?
It is recommended that the board, is that what yeah? It is recommended that the board approve the 2025 to 2027 licensed contract between the Newburgh Dundee School District and the Newburgh Education Association as presented.
Second.
Any further questions? Okay. Well,
Eagle eye.
you're on it. We'll call for the vote. All in favor, say aye. Aye.
Hey,
Motion carries unanimously.
no, that's good. That's
Yeah.
been a long process. I'm excited to move forward and like I said, the nature of the negotiations had been so toxic before, and it was a very good negotiation where folks got to speak their minds, and so I'm just really happy that that's approved. So
Well, and I think that's a testament to you, Dave, your leadership and your willingness to be collaborative, and for your care and compassion for the people who work in the buildings. So thank you.
Yeah, I was going to say the same. That it's a big deal. That last vote is a big deal. I mean, as someone who has been a classroom teacher and for whom a contract like this has allowed my family to, like that's a big deal. These are the people that are making magic happen in our classrooms. And thank you, Dave, for your leadership. I also just want to say congratulations to the union and our teachers for having a contract that's going to help govern their work.
Yeah, and for them, we're always stepping up in Newburgh, always. Thank you. Okay, Tammy, you have one more thing to bring it on home.
All right, so a little hiccup on this one, which is in front of you. It says that we will have 8 furlough days. So let's talk about that. I think that so that is just an error as part of this negotiation. We knew that We weren't financially where we need to be to go from 8 to 0. And so as part of our negotiation, we landed on reducing to 5 furlough days, which is a step toward where we want to be. And that will still give folks, some additional money that is well deserved in their pockets, because I don't think they saw much of that this past year with the reduction in days. So we're excited to go down to 5. We did meet after NEA negotiations. We did meet with both the union president for NEA and OSEA, Jen Esmond, and we worked together on placing these furlough days so that everybody had some input and say. We tried to avoid the beginning of the year. We thought it was important to start the year off on the right foot. We have strategically placed our furlough days, the first one being the day before Veterans Day. Veterans Day falls on a Tuesday this year. And then, so we thought that placing that on the Monday would give folks a 4-day weekend. It just made sense since that's always kind of a wonky one because it can sometimes fall in the middle of the week. The second one is January 5th, and that is the Monday after winter break. So adding an additional day to winter break, and then we come back and actually have some professional development on Tuesday, and students, school will resume for our students on Wednesday. February, Monday the 9th. There may be a big sporting event that happens on the 8th. And so there was a real interest in wanting the 9th, the day after the Super Bowl, off. And so that seemed to be a common theme from both sides. The next day falls in April. We call that the longest month of the school year. It's a pretty long stretch between spring break and the end of school. And so strategically placing a furlough day for a Friday 3-day weekend, and then the very last one, adding it on to Memorial Day, gives families an opportunity to go out of town, travel, camping, gives them an extra day, and then gives our educators an extra day to recoup for those last couple of weeks of school. So any questions?
During the budget cycle, we had budgeted for 6. Was that correct? And we got one more out of there with perfect.
Correct.
How does do the trimesters remain fairly equitable in terms of
of
number
days?
Mhm.
Correct.
Okay.
Yep.
I couldn't count that fast.
That's okay. I think first trimester is a little bit longer, and there's some strategic thought behind that, Andy. At the beginning of the year, there's a lot of nuts and bolts that we do with our students, and it happens K-12. Like we're going over some of the student rights and responsibilities. We're having some extra home rooms. We're teaching kids about evacuation drills. And so we embed a lot of that in the beginning of the year. So we do intentionally make first trimester a little bit longer to kind of offset some of those very important but non curricular activities.
I'll also say built into our negotiations with the union is some trigger language around where the ending fund balance is and where we would put back another day. So we were working with the union trying to balance that, just so that you know that that's out there in this contract. So it's in an MOU. It's not in the actual contract. But just wanted you to know that that was there. I'll also say that the furlough days, it'll be the number one thing would be to be 0 furlough days next year. It made this negotiation extremely hard, and it just is creating a lot of. So we'll be working all year long around next year having 0 furlough days. That's kind of the goal. That's going to mean, though, that's going to be some issues for us, money wise. Nate will present coming up here. The ending fund balance is still trending positive. We're in a better spot, but we're not out of the woods. And eliminating the furlough days into the next budget cycle will be another challenge for us as we're moving forward. But it's just something that we do have to get rid of because of not only we need kids in school, but it's also creating other issues.
Okay,
Is there-
so go, I'm sorry.
Is there an order in which the furlough days would be returned?
Right now, the one that's looking, the November, I think is going to happen before we're too far. That 2/9 is the one that we kind of had some discussions around. That would be one that we would probably pluck off first.
Okay.
And then I would start looking at I don't know, from there, they get a little bit more interesting in that the January PD day, that's going to come right after Christmas. I'm not sure we're going to have the information we need to put that one back. So then I think you're looking at April and May. Probably April would be my next, because that's still really good teaching time. So,
Thanks.
yep.
Okay, so we need a motion that reflects the 5 furlough days.
Yep. I move that the Newburgh Dundee School District Board of Directors approve the revised academic calendar for the 2025-2026 school year as amended.
Second, but I think it is just as presented, because aren't we just?
Well,
It's not, I know, but it's not the language of that we're approving. We're just approving the academic calendar. If you-
Part of the language we have to prove.
Okay.
So
second, anyway.
Any further questions? I'll call for the vote. All in favor, say aye. Aye.
Okay.
Motion carries unanimously. Thank you.
Okay.
Dave,
Thank you.
Tammy, thank you very much for all your work. Dave, do you want to start us off on the board superintendent comments?
Yeah, I'd love to. Well, our administrators are back at work, and we hit the ground running, not just with tasks to get ready for the first day of school, which they're all deeply in with, but we're also started with a lot of deep work. We started with solution tree training on professional learning communities. They did 2 days last week. It's the last 2. They've done 4 days total on kind of, it's more than just a meeting format. It's a framework for how we work together professionally. So getting principals trained in that's important, and ensures that every grade level, every subject team is focused on student learning first, uses evidence to guide decisions. Today, we have a new data system called Panorama. Today, the administrators were trained on it. In the in-service, we'll be training all staff on it. It greatly simplifies our ability to figure out which kids are missing school, or local assessments are trending down or trending up. Big improvements there. And then again, we just need to figure out which kids are slipping through the cracks and help them. It's one of the clearest ways we can live out our promise to know every learner and teach well is with this professional learning communities. And our principals now have been through 4 days of training in the last 3 months. Tomorrow we'll wrap up the 3rd day of our McCrell Balanced Leadership Training. So all administrators being trained around what administrative practices have the biggest output on student achievement. We'll be on day 3. As I presented to principals today around the purpose of our schools and what our promise is to parents, it was really interesting because I was reading the slides from our presenter tomorrow, and they're all lining up. So I thought that was very interesting because I didn't plan that, but it was interesting to see that what Kent is going to present tomorrow is lining up on this. And then we're sprinting towards the start of the year. We're like a week and a half. On August 25th, our staff officially report ready to welcome students. On September 2nd, our first group of students will walk through the doors. And by September 8th, all classrooms will be full again. Kindergarten, we are working with parents and with schools right now because we want to give an opportunity for our teachers to know families. So rather than have every family report on day one, we've got a schedule going for kindergartners that we're going to work through so that they can learn systems and we can kind of onboard them in a better way. We're in full swing though, preparing, planning, fine tuning. More than that, we're excited. I'm excited to see students again, and I'm excited to see staff. And it was wonderful today to finally get all our administrators because we've been going in different directions the first week. We're excited to partner with families. So this is good work. It's work that matters. And so we're ready to begin it. So that's kind of where we're at right now.
Start by saying thank you again to Rebecca Pyros for being an advocate for our community and our students and all of us. It was great training. I'm glad that we got to do that. And I learned some things that I feel like I probably should have known already, which is good and problematic. Also want to say thank you to all of the staff who've been working over the summer on policies and getting the contract signed. It's really awesome. So appreciative. The teachers union as well. And then, yeah, just more locally with Joe and Austin. It was fun. Our incoming kindergarten class, my son is going to be in there, along with Director Wolfers, actually, child. And one of the parents really wanted to find a way to get our kids together to get a chance to interact before going to that first day. So we had a few times where we met up at the park. We had a few teachers come out. Principal Carsley came out just to say hi to all the kids. And it was just a really awesome community building to, filling in those voids, not having those federal grants for the Head Start, was it called? Anyways, it was really nice to be able to get a chance to do stuff in the community for the school outside of the school. So I just wanted to shout that out.
Yeah, mine might be short and sweet, but again, Rebecca Pyros and Jean, just for their support of the school system and district. I've said this before, they've been a lifelong friends of my wife's family, and so I've known them for a long, long time. I'm glad we were able to close this chapter. But as Director Byerly said, Rebecca will always bring it back to the children, which is her to the fullest. So, but again, I was glad we were able to do that. Training was well done. Learned a lot as well. I'm excited for the school year, though for the first time I have no kids in the school district, so my comments may be light this next couple years at least. So, but I am excited that everybody's excited about getting back all the work that was done over the summer and continued as we ramp up for the first week of September. I'm happy that we have a new assistant, Jackie. I will have to say, Dave, I think next time she needs a seat at the table because she's doing notes on her lap, and that's not the best. So
we will get her a seat.
Okay. Other than that, yeah, I'm looking forward to the next meeting. So thanks.
Okay, I'm also going to thank Rebecca. It just really hurts my heart to know that, that was an experience that anybody had, but of all the people in the world, the sweetest, most generous and kind woman, it's hard for me to sort of wrap my head around what she experienced, but she's been so gracious with us since we got that, the letter from the Department of Education. I had a fun event. We went to the Sayonara party for the Wadamaya group. Was that last week?
Yeah.
Wow. Wow. I mean, the kids, it was so much fun. And to hear the exchange, the some speeches that the students made, and they did some dancing, and there was wonderful food that were sort of represented I think it was each CV kid, their family's favorite dish.
Yes.
So it was this potluck of like the family, wonderful things. It was just very wonderful. I want to do a little, I don't know if I'm stealing your thunder, but I saw a post on Dundee Community Conversations from a woman named Linda Stock who said, "Hey, let's have a cleanup party at Dundee Elementary School." And yes, it's all approved by the district. And I'm like, what? So I double checked, and there was maybe some miscommunication, but a big group showed up at Dundee Elementary School. Some landscaping professionals, people just really showed up and came out on a Saturday. And this is a community member. Again, this is very typical of Newburgh. A person who sees something and says, "Hey, we can get a group of people together and take care of that." I need to do a big shout out to Jan Hart, who runs the resource room. I found out about a family who had a lot of needs for the kids in the family, and I sent her a text, and she said, "I've got it. I'll have it for you all by Friday." And she is such an amazing, caring person in the resource room world to really just say, "I've got this fun thing and I'm going to add this, and I've got, it's going to make that beginning of school just so much easier and the stress reduced for that family." I'm just really proud of her. We are going to have an onboarding meeting with the student reps, just so everybody knows. Jeremy and I are going to participate that. And then I'm just very excited for the first day of school. So I feel like it's going to be a great year.
Echoing everyone's sentiments about Rebecca and Jean, and I agree with you in the heartache, but I also feel very honored to be in this position and have the opportunity to learn in this setting. And I just really appreciate everybody who played a part in the process of bringing that training to us today, and it will not be forgotten by any of us. I am so excited about the beginning of the school year. I know that there are so many teachers out there who are already setting up their classrooms, even though they are not on contract, but that is what we do. The magic making that occurs in the end of the summer is it's one of my very favorite things. And I'm so excited to hear about all of the collaboration and professional development that our administrators are getting. I just think that is just an incredible support. And I know that is setting up their school year for success. So thank you, Dave and team, for facilitating all of that. I think that you guys are doing an incredible job. We had that meeting on July 1. And then I was thinking about it throughout July. I think that period of time from July 1 until today is the longest that we had ever gone without meeting. Certainly the longest that I've gone. And yesterday, I came in yesterday afternoon for a brief meeting with Dave and Celeste, and I came in with such a smile on my face, and I went home with such a smile on my face, and I found myself missing this work in July, which last July was my first month, and I thought, what? What is this? I'm just feeling so grateful and excited. We have so many cool things coming up this year. I think that we as a board are really feeling, at least I am feeling, so much more settled than I was last year at this point, and confident in what we need to do. I appreciate tech helping us out with these Chromebooks. I'm excited to not have so many piles of paper. And I just think we've got such a good thing going in this town. And I'm just really pumped. I wanted to shout out, just like you have some kindergarten get-togethers happening at JA. We found out recently that the middle schools are doing a 6th grade rising day in, I think it's August 21, where 6th graders at both Mountain View and CV will get to go and be there for half a day and meet people and I'm sure do activities and kind of get a lay of the land. And I just think those programs dramatically help our students who are in transition. So thank you to the middle school teams who are helping to facilitate that too. So that is all. Thank you.
Right. I just want to say I know why I've been moved over here, because given the length of some of my but I will say tonight I have special permission to go long because I went to the OSBA summer board conference. First and foremost, I want to second Director Hayden. Welcome, Jackie. It was a pleasure to meet you over the weekend. I really look forward to what you're going to bring to our district. So welcome. And I'll second but not repeat all of the gratitude for Rebecca and Jean and what they've brought to our community. I also, at the very, very beginning of the meeting, Dave, you thanked the Austin Foundation. I want to come back to that and just say that is such a beautiful example of the partnerships that happen in a community that take relationships. And so thanks to everyone who is involved in stoking those relationships and maintaining those, because we're all doing, at the end of the day, we're all doing work that is pointed in the same direction. So I'm really grateful for that. Chair Bridges mentioned the Dundee event. I just want to encourage folks. There are volunteer opportunities around landscaping, I think, at all of our schools. So if you're looking for something, that might be it. Okay. One final shout out too. I know a lot of our athletics staff have been working hard over the summer. I will have 2 high schoolers this year, and both have already been working with coaching staffs and doing concussion baseline testing. And I sent my youngest to concussion testing yesterday and came back with like 8 tabs open of school clothes. So students are also looking forward to the year in many ways. The OSBA Summer Board Conference, I want to thank the district for facilitating me going to that, and Jackie as well, was down in Salem Friday, Saturday, and Sunday. This was an opportunity for us to take our mandatory public meeting law training. So elected officials have to take a mandatory training, so this fulfilled that. We also received some key legislative updates coming out of the long session. Jackie Olson from OASBO, whom our board knows, gave a very excellent overview of school finance. We talked with the board development team at OSBA. They shared some of the research on what makes school boards effective. And I hope it won't come as a surprise that boards do have an impact on student achievement. And any guesses on the number one thing that board members can do to contribute to student achievement? Believing that all students can learn at high levels. So there were a series of hot topic tables that we could go get more information at. Jackie and I were at least one of those together. Some of those hot topics were the executive order from the governor requiring a cell phone policy in place, board stipends. So board members now in public agencies are eligible to receive a stipend. For the record, I am not in favor of that here in our current budget situation. Senate Bill 141, also known as the Education Accountability Act, has a lot of implications for what we're going to be doing this coming year, and particularly in 26-27. Some guidelines on public comments, many things we are doing, but also just some other reminders. And then mostly just a chance to connect and collaborate with board members from other districts. So thinking particularly about NISA, Springfield, Beaverton, Tigard, Tualatin. I had some really good conversations with folks doing this work. Dayton, just down the road. So I'm excited to connect with board members in other districts in various ways. So I think I'll stop there. Also, we got some nifty little notebooks from compliments of OSBA. So thank you to the OSBA staff and the PACE staff for making that conference a success.
I'll just say a few thank yous. One to teachers for all the prep and our administrative leadership as well for all the prep for a smooth school year coming up. Having a Chromebook will be very helpful for note taking, and also, you don't want to store paper notes of mine, I'm sure. So I can email you the PDF. Helpful tools. And one of my sons, well, both of my sons have been playing football, but the high school football program has been doing 7 a.m. workouts for the majority of the summer. And it's really helped keep my son on the rails. And so thank you for all of those efforts to coaches and staff investing in our students.
Well, thank you. Well, I think we're going to get out of here before 9. Meeting adjourned.
Meeting adjourned.